Well, good morning, everyone. The clock's just ticked over to 9 o'clock. Welcome to day 4 of hearing 11. Could you just start us off with the yeah, thank you.
Tu teke mai rā. Tangihia ngā mate huhua I raro I ngā manga tupuna. Haere koutou rā ki ngā ringa atua o te atua. Haere, oki mai rā. Ka huri taku waro ki a tātou te ata nei rata mihi ki o koutou. Kia kaha, kia mai a tātou, kia manawa nui. Nō reira, tō tātou kara kia timata o te rā nei. E tau nei ki rongi a tātou katoa te wairua o ngā mātua tupuna. Nā rātou waka toko te ara hei hikoina mā tātou ngā uri. Waka tōki o tātou ngākau ki ngā tikanga, hei ara takingahi a tātou. Kia ngākau noi ki te hāpai a tātou mahi katoa I roto I te pono I te tika I te māramatanga me te aroa nō tēti. Hoi ara e rongo wakari aki kinonga, tūturu waka maua kia tēnā. Hui e tā ki. Kia mai tātou.
Thank you very much. Great way to start. Really, thank you very much. So I think everyone in the room's been to one of these hearings before, is that right?
Right, this time.
For you, Mr. Much?
Mr. Stevens.
Mr. Stevens, okay, fine. Well, welcome everyone. We have a tradition I would like to just have everyone introduce themselves each time we start the day. So I think everyone knows my name is Stephen Daish. I'm the hearings panel chair, and today for this hearing 11, Commissioner David McMahon is assisting. So David is well known to everyone as well. So Christine, we need to do health and safety first. So Christine, just introduce yourself and then do your health and safety thing.
Good morning everyone, I'm Christine Rommel and I'm one of the administrators for the hearings. In the event of an emergency, please follow the instructions of council staff. Please exit through the main entrance. Once you reach the footpath, please turn right and walk towards Pukura Park, congregating outside the Spark building. But please just keep in mind not to block the footpath for other users. Staff will guide you to an alternative route if necessary. If there's an earthquake, drop cover and hold where possible. And please remain where you are until further notice is given. The toilets are just out the door here to the left, and the cafeteria is upstairs. And for the COVID level we're currently at the moment, masks to be worn in the caf and outside, and if you're comfortable in here, they can be removed.
Thank you very much, Christine. Thank you. Start with you.
My name is Jacob Steiner. I'm a reporting officer for NDDC. I have worked on the Section 42A report in relation to transport and as well as submissions relating to the National Grid.
Keith Holsworth, here. I'll be submitting later on this afternoon for utilities.
Thank you.
I'm just here to support today. I'm from Nāmahanga and Ngāti Tai.
Thank you very much.
Good morning, Jason Stevens from Graham Petroleum, so engineering manager.
Welcome, Jason.
Rebecca here at Graham Petroleum.
Hi again, Rebecca. Bryce, do you want to just introduce yourself again to us?
Thank you, Commissioners. My name is Karen Price and I'm here as Counsel for Greymouth Petroleum.
Welcome back, Karen, sorry. Yes, Jennifer.
Good morning, my name is Jennifer Carville. I'm the planner appearing this morning for Greymouth Petroleum.
Yes, good morning, Jennifer. Hamish.
Good morning, I'm Hamish Harwood. I'm a lawyer assisting the council in these hearings.
Thank you. Sarah.
Morning, Tato. Sarah Makoti for Taitanga. We're speaking this afternoon.
Thank you, Sarah. And Damien.
Good morning, everyone. I'm Jamie Cannon. I'm a consultant planner who is working on behalf of New Plymouth District Council. I prepared the Network Utilities chapter of the proposed district plan and the 42A report.
Thank you, Jamie. And Maria?
Kia ora koutou, Maria Hokora from Te Kahui o Taranaki, appearing later today. Kia ora.
Thank you very much. Just in terms of timing, we had quite a long session yesterday, finished at 6:30. It was a very good day with several of the submitters. But just my sense is that we probably should be able to work our way through these submissions and evidence this morning. That's just my sense of having read the evidence and the range of questions we have. So just for probably Sarah and Maria, Keith, you may be on before lunch, so just to let you know, we'll just roll with things. So that's fine. So we do have an apology from Hilary Walker from Federated Farmers, which she can't be here. I'll just read out an email that she sent in this morning, just for the record. Sorry for the late notice, but please be advised that Federated Farmers New Zealand is unable to present today. She's needing to look after a sick child. We only had a very minor and discreet matter to raise, and it's not worth getting someone else to address on my behalf. Our scheduled time is set for 9 AM. Please pass on my apologies to the hearing panel. There will be no need for me to table the speaking notes. We can register a level of comfort with the Section 42A report recommendations as they apply to the Federated Farmer New Zealand submission points allocated to hearing 11. So that's just for the record, and we have a copy of that. So that's very helpful. Thank you for passing that on, Christine. So the first order of the day is with Greymouth Petroleum Limited, and Karen, we've received your legal submissions. Thank you very much for those. Very interesting as always. And we'll hand over to you to run the case.
Okay, thank you. I think there's some hard copies that Rebecca has that she's handing up now to the hearings coordinator in case there is anyone there in the room that would like a copy.
Thank you.
So I am going to just speak to my submissions. I was, as you know, online on Tuesday, and so there are a number of questions that you asked in that Tuesday session, which I think would be best directed to Jason, our pipeline manager. And what I will do is, after he's read his executive summary, I will lead him through a number of the questions and then make them available for questioning with you.
That's really, really helpful. Thank you, Karen. Appreciate that.
Okay, so beginning at page 1, we're here from Greymouth, and we're here to look at the network utilities and transport chapters. The detailed description of Greymouth and its operations has already been set out in the submissions, which you heard in hearing number 1. But in summary, Greymouth is New Zealand owned and operated, and it has strategic importance in energy activities to the region and the district, and that's recognised in the applicable planning framework. Greymouth is a network utility operator as defined in the proposed plan in the RMA, and Greymouth owns and operates 65 pipelines with a combined length of 126 kilometres. Now, attached to my evidence, I sent through to the hearings coordinator a plan showing the extensive Greymouth network, those 65 pipelines. Greymouth's activities rely on an efficient and functioning transport system and have potential to generate transport effects, including associated with day-to-day operation, maintenance and construction activities. The network utility and transport provisions in the proposed plan are therefore very important for Greymouth, and Greymouth's activities, as you know, are undertaken predominantly within the rural production zone. Its pipelines are largely within the rural production zone and are commonly located in the District Council's road reserve. So Greymouth is very supportive of the network utility provisions in the proposed plan as recommended in the Network Utility Section 42A report, on the basis that they generally are appropriate to enable Greymouth's activities and they appropriately manage adverse effects. But we do seek several amendments to the policies and rules. In the transport section, we are also generally supportive of the proposed plan and the Section 42A report, and we seek only 2 transport policy amendments. So all the changes sought by Greymouth to the network utilities and transport provisions have been set out and addressed very comprehensively in Ms. Carville's evidence. Mr. Stevenson's evidence was aimed at providing additional detailed context for you in respect of certain pipeline matters. And one of the particular issues there is the permitted pipeline pressure threshold and the remediation that might be required. Whether that should, and we are opposed to mandatory removal of redundant underground pipelines, and we'll go through that in quite a bit of detail. While it's not been addressed in Ms. Carville's evidence, Greymouth does not support the extent of the additional protection that was outlined by First Gas in this hearing on Tuesday. While Greymouth agrees that safety with respect to gas transmission pipelines is critical, it considers that the Australian New Zealand Standard 2885, which has been embodied in the pipeline regulations, appropriately manages all safety aspects. Given the detailed evidence for Greymouth, these submissions are only going to address certain key issues where it's considered that legal submissions might assist the panel.
Ms. Price, could we just pause there, just so that I can understand a bit of the context and the map that you've attached to your evidence? Very clear map. I just was interested in the background and status to the 2 permit areas that don't seem to be developed, PMP 50509 and PEP 60749. Are those permits under active investigation, those areas?
Commissioner Dace, I'm going to see if the 2 Greymouth parties in the room are able to answer that. Otherwise, I'm going to have to get you a response in writing back on that.
Okay, well, they probably, I dare say, they might be able to give us some enlightenment. So, what's the status of those?
PMP 509 is a petroleum mining permit, and
yes.
So we have one active well, RMP4, within that permit. There's another site that those wells are inactive. So that's I suppose a current production permit.
So that produces gas.
Produces oil.
Oil. Okay.
Yeah, but it's only very small.
Very small.
And so it doesn't have any pipelines.
Okay, and that's on the land.
The land sort of near the port.
Near the port. Okay, thank you.
And PEP 60749 is a new exploration permit.
Yes.
That I think my understanding is just recently been granted.
Thank you. That's great. Thank you.
Okay, so moving on to policy NUP4, which is managed.
Actually, Ms. Price, just before you do, sorry, I had some questions about your 4.4. Okay. Two things there that interest me, particularly as you say, these matters aren't addressed in Ms. Carville's evidence. You're saying that Greymouth doesn't support the relief sought by First Gas in relation to reverse sensitivity policies and rules around gas transmission pipelines. And I see in the footnote, Greymouth have lodged a further submission to that extent. Is that correct?
Correct. We agree with the response of the Section 42A report.
I understand that.
And we disagree with the extent of the buffer areas that are being sought.
Okay, so you don't disagree with the principle of protection of buffer areas for gas transmission?
Correct.
That's the extent of the buffer.
Correct.
Okay, thank you. And you say that the combined standard 2885 or manage safety aspects associated with transmission.
Correct. It's a very, very detailed and prescriptive code for managing all aspects of public safety associated with the pipelines.
Yes, understand that. Is Greymouth relying on compliance with that code also in terms of distribution?
Correct.
Okay. And is that reflected in the release sort in terms of the extent of the buffer that Greymouth is seeking?
Correct.
Okay. So Greymouth's case is made up of a combination of the joint benefit from the guidelines plus any additional buffer provided through the district plan. Is that it in a nutshell?
Correct, but there are also additional other legal protections. So you'll be aware that where the pipelines cross private land, there is usually an easement in place, and that offers quite a lot of protection. You know, it governs the above ground activities that can happen for a buried pipeline.
Yes. So from a section 32 perspective, and we can discuss this with Ms. Carville, are you saying that the relief sought by Greymouth involves no wastage in terms of additional buffer that's not required? Is that the position? That
Correct. Correct.
Okay, thank you.
Okay, continuing on then. NUP4 includes an absolute requirement for network utilities to adopt sensitive design to integrate network utilities within the site, existing built form and or land form, and to maintain the character and amenity of the surrounding area. Ms. Carville has identified no higher order policy direction nor other proposed plan provisions supporting such an approach. I submit that this blanket absolute requirement is not necessary or appropriate. A proposed network utility may be in an entirely unsensitive location, and or adopting sensitive design may involve costs that are out of all proportion with any adverse effects. Therefore, Greymouth proposes that network utilities be required to avoid, remedy or mitigate adverse effects on character and amenity through the use of sensitive design where practicable. I submit that this is still a stringent policy position, which gives effect to the regional policy statement, in particular INF Policy 1, and which is appropriate in the context of the other proposed plan provisions. And there are a number of footnotes there that goes with that text. Practicable is a word which is used in the RMA and frequently in plans throughout the country, including in the highly relevant RPS INF Policy 1 and the recent National Policy Statement for Freshwater Management of 2020. It is also proposed to be included elsewhere in this proposed plan. Practicable as a qualifier is often used as recognition of the practical realities relating to infrastructure and network utilities. While the Section 42A report author is concerned that the addition of where practicable would add a level of subjectivity to the policy, I submit that the meaning of practicable is well understood and has been subject to judicial decisions which guide its interpretation. I submit that a qualifier of this nature is entirely appropriate and in fact desirable. I won't canvass all the cases, but I have included them in an extensive footnote.
Ms. Price,
yes.
I am very grateful for your extensive footnote. That analysis is extremely helpful, just to be put in that concise way. Looking through the cases and the definitions and how they're used in both national and regional policy instruments. We've been grappling, as you know, with these qualifiers. They appear in policies and plans. They're quite a common technique. They do come with them obviously a level of discretion, which I think you'd accept that discretion needs to be applied to a word like that by someone, whether it's the applicant, the council or decision makers. I have a specific question about the definition of practicable as it's captured in the Whakatane case by the court, your footnote 15, which references paragraph 53 of that case, and it establishes 7 criteria for looking at the term practicable, which to my read is very similar to the matters that a BPO assessment covers for discharges.
Yes.
My question to you is, might that type of definition be useful in the plan? Because my reason for asking that is all practitioners, lawyers, decision makers always reaching for how to accommodate the term practicable. So certainly as a practitioner, if that was given as direction, I know that can be found through trawling through case law, which lawyers are very good at, but not always evident to plan users. So there may be some scope issues with this, but it's just a thought that occurred to me just looking through the way the court defined that term in the Whakatane case.
Yes, so I agree with you. I think it is useful to have a definition. I think what concerns us here is that practicable is being used in other parts of the plan, and I suspect there are different Section 42A authors involved, and so there's just not been a bit of joining up that needs to happen behind the scenes. But given that it is being used in different parts, I always think it's good if there is some additional interpretation for words like this. So yes, I would be supportive of having some kind of definition. Remember always that case law is never static and it may get developed by the court, but I do think that those 7 criteria are useful guidance for anyone using the plan.
They seem to all be sensible and relevant when assessing these sorts of matters, and even if case law does change, having them locked in the plan is clear guidance.
Yes, they're good common sense, and common sense never goes out of fashion.
Yes. All right, thank you for that assistance. I think Commissioner McMahon might have another question.
I do. Thank you, Stephen. In relation to the potential use of this qualifier, and I acknowledge there's a planning component to this question, but from a legal perspective, one of the things the panel's been grappling with is if we were to use qualifiers, where are they best landed? Are they best landed at the objective level, the policy level, or in the matters of discretion? And I'm interested to see that the position of yourself, Ms. Carville, is that this qualifier should be added to a policy in UP4. We heard yesterday from Transpower suggesting a similar qualifier in relation to NU02 at the objective level. And I wondered, from a legal perspective, is there any guidance in case law as to where one is going to use qualifiers, where they are best situated? Given that objectives are usually a statement of outcome, and policies are usually a statement of the method, the how question, how that outcome is to be achieved, and then the rules go on to finesse that how question in a statutory permitted, enabling, controlled, discretionary respect.
Yes, I understand the question. I can't at the moment think of case law off the top of my head, but what I will endeavour to do is do that research for you, and I will supply a written response.
That would be really useful.
Okay. So just continuing at page 5, policy NUP8 is notified and as recommended in the Network Utilities Section 42A report, requires that reverse sensitivity effects are minimised where necessary, whereas Greymouth seeks that such effects should be avoided. The relief sought by Greymouth is consistent with the panel's new infrastructure and energy objective 1E1, as set out in its interim guidance in minute 9, which requires that reverse sensitivity effects are avoided. As identified in Ms. Carville's evidence, objectives NU01 and NU02 recognise the important role network utilities play, and objective NU03 seeks to ensure that network utilities are not constrained or compromised by other activities. This anchors the policy context for placing a high priority on protection of network utilities.
Ms. Price, I think you were here when Ms. Cannon presented her overview on day one. Were you listening to that?
Yes, I think so.
Yes. So Ms. Cannon has indicated to us that she doesn't necessarily support that interim guidance, i.e. one that we've just released for, I suppose, for dialogue, let's call it that, this
Yes.
stage. And we'll be following that up with some more, perhaps some more reasoning and background in her right to reply. We issued the interim guidance in minute 9, really as a work in progress, really encouraging and seeking input on support or otherwise, or different ideas through the plan as it evolves. So given that Ms. Cannon is not supporting this position, at least currently, at any time the panel is open to further legal submissions, I suppose, primarily, or planning views around the strategic objectives interim guidance version, particularly as they flow through, as we're doing now, into the next levels of the plan around district-wide or zone-based provisions, and of course that hierarchy working all the way through the plans is quite important. So that's really just an observation that certainly we're always open to dialogue, opinions being brought to us through the course of the hearing. So that was just an invitation, really.
Thank you. Thank you for that invitation. It's noted, and we anticipate coming back to you on it.
Thank you.
Again, I do have a question, apologies, in relation to this matter. We've heard similar relief being requested by TransPower yesterday, Ms. Price. They pointed to higher order document in terms of the MPS-ET for the avoidance word. Obviously, your client doesn't benefit from that MPS, but is there, from a legal perspective, is there any higher order document that you would point to for that relief for network utilities generally?
No, I cannot identify one right now, but I will also come back to you on that one.
These questions, I guess, are also an opportunity for Ms. Carville to respond to at the appropriate time. So I guess I'm just giving her some advance warning on those, and I'm sure she's taking notes.
Okay, thank you. Okay, now to the matter of leaving in place redundant underground pipelines. Greymouth's submission opposes the requirement for all structures that are no longer required for network utility purposes to be removed within 6 months of becoming redundant. The Network Utilities Section 42A report includes recommendations that the timeframe for removal be extended from 6 months to 2 years, but that the requirement to remove all structures should still remain. Greymouth considers that a blanket requirement within the permitted activity rules for the removal of all redundant structures above ground and underground is inappropriate. The Section 42A report acknowledges that it may not always be practicable to remove redundant infrastructure within the proposed timeframes, and that leaving structures in place may result in better environmental outcomes. Ms. Carville's analysis is also that in many scenarios, the overall level of adverse effects on the environment of remediation and leaving in situ will be less than the environmental effects of removal. Notwithstanding this, the proposed plan incentivises removal by making it a permitted activity and requiring restricted discretionary consent for leaving infrastructure in place. Greymouth's pipeline network is generally located within the road reserve alongside other utilities or in private land. Easements in perpetuity are the common landowner agreements by which Greymouth is granted access to private land for its pipeline network. As these easements are in perpetuity, they generally do not contain provisions contemplating decommissioning activities. However, there is a focus on ensuring minimal interference with the landowner's above-ground rural activities. These circumstances mean that decisions regarding abandonment of pipelines remains with the network operator Greymouth. In practice, it is extremely rare for Greymouth to abandon a pipeline. For economic, efficiency and practical reasons, it is far more likely to ensure its pipeline remains in good working order in accordance with the Australian New Zealand standard than to abandon it. If a pipeline is to be abandoned, there is a very detailed regime provided in that standard that also requires assessment of a range of relevant potential environmental effects. Requiring consent to leave in situ adds nothing to the standard regime, yet it could lead to perverse outcomes where appropriate decommissioning decisions are deferred. Greymouth agrees that above-ground infrastructure should be required to be removed. However, for the reasons set out in Greymouth's evidence, Greymouth is seeking that the proposed plan should also provide for the remediation of pipelines in situ, where this is undertaken in accordance with the very comprehensive processes under the Australian-New Zealand 2885 pipelines, gas and liquid petroleum standards. And those have been incorporated through the health and safety pipeline regulations. That standard requires above-ground piping to be removed, but provides for the leaving in place of underground pipelines subject to a robust abandonment process. This process includes requirements relating to subsidence and contamination risks to soil or groundwater. The relief sought by Greymouth is consistent with the standard, whereas the wording recommended in the Section 42A report is inconsistent with the position in the pipeline regulations. By cross-referencing to the standard, the wording proposed in Ms. Carville's evidence is now more precise and certain than that contained in Greymouth's original submission, which was a valid issue raised in the Section 42A report. Requiring resource consent to leave pipelines in place is unnecessarily duplicative with associated time, cost, efficiency implications, given that the decommissioning of pipelines is already subject to a comprehensive regulatory regime under the health and safety and employment regulations. It may also lead to inefficient relitigation of issues under the two processes. The network utility effects standards and other applicable rules and standards in the proposed plan and any applicable regional plan requirements would still apply, appropriately managing adverse effects. In Royal Forest and Bird Protection Society and Whakatane District Council, the court held that where the purpose of the RMA and the objectives of the plan can be met by a less restrictive regime, then that regime should be adopted. Such an approach reflects the requirement to examine the efficiency of the provision. It is also to promote the purpose of the RMA by enabling people to provide for their well-being while addressing the effects of their activities. Greymouth acknowledges that parties have raised potential cultural issues associated with leaving structures in place. Based on Greymouth's understanding of the issues, the processes required under the pipeline regulations may go some way to addressing those concerns. The evidence of Keith Holthwich on behalf of Ngāti Rahiri Papu states the following with respect to NUR2. We can agree with the 2-year period to remove redundant utilities, but note that at times it may be more culturally and environmentally appropriate to leave such utilities in place.
I have a couple of questions about that section.
Sure.
The second sentence of your 7.4, which is a practical question, and also see whether Mr. Stevenson has a response. But my question is that, do you accept that there must be a time when they will be abandoned? these are not forever assets, given the sorts of resources we're dealing with. Would you accept that or not?
They have a much longer working life than I anticipated when I started answering questions about this, but it's possibly more appropriate for Mr. Stevenson, who is the pipeline expert, to answer the questions.
Yes.
But as I understand, a very well maintained pipeline that always stays in commission has a very long asset life.
Sure, Mr. Stevenson.
Thank you for the question. There's two aspects, I suppose. In their current form of oil and gas production, you would have a limited time frame in terms of the permit duration, and for that matter, the production.
The resource.
The resource, yeah, actual production of the resource. But I think where industry is going is we're in a transition to look at alternative fuels, and I think the infrastructure that we have in place is an important element to have in mind, that is to reuse that existing infrastructure to integrate with future forms of energy.
Right.
So
long life then.
it would be a shame not to. There's a lot of infrastructure that is there. It would be a shame to not have that available for reuse in the future. That
follows. We might as well ask the second question, which is a Mr. Stevenson question too, while we're on it. Presumably, if you do remediate, fill it up with concrete or something, that means it can't be reused.
Correct.
Yes. And I'm particularly interested in the effects of contamination risks to soil or groundwater from having significant structures sort of sitting under the ground. That's one of the things you cover in your risk assessments and remediation strategies.
Correct. Yeah. Yes. So the key first part is cleaning. So we pick pipelines, which is a plastic or
your operations guy showed us all about that.
Okay.
Yeah, great. So that was.
So you have sort of understanding the context of that, and we'll do that until we're satisfied the lines are clean. And then as part of that detailed process is looking through the, I suppose the length and the contour of the land that pipeline goes through. Consider water crossings and what features there are on the easement that line goes through.
Yes.
And the other ones, road crossings is the other.
Yes.
Important one from the subsidence.
Yes. But over time, these, I know that there's a coating on the steel, so does that, I'm just interested.
I suppose eventually, yeah.
Eventually it'll break down. Yes. Yes. I always reminded of West Coast when you see all the old mine workings left, sort of rusting away and over a long time. So it's just, that is one of the effects that you do tune your mind to, obviously. Thank you. That's helpful. You have another question?
I do. I have three. Mr. Price, these 9 paragraphs, as I said, there's three aspects, but this issue is being canvassed also previously in the hearing by a couple of others, Tide Energy, who in fact are relying on grey mouse relief.
Yes.
But also the oil companies also, and their planner gave some evidence on that a couple of days ago. Firstly, I understand the relief in its entirety.
Yes.
There are 2 rules that are potentially relevant here, NUR2 and NUR19. And for some reason, Todd focused on NUR2, the oil company focused on NUR19, and your clients focused on both of them in terms of the relief. And I questioned Ms. Megan Barr for oil companies about that, and her answer was that NUR19 is the appropriate rule because it specifically deals with this matter, whereas NUR2 is more about underground network utilities generally, and she relied on the words not provided for in another rule in this table at the end of that rule. And so I guess from an effective and efficiency point of view, is there a need to have clause 3 in NUR2 when you might have clause 5 in NUR19? Again, Ms. Carville might want to comment on that, but just from an effective and efficiency perspective. Ms. Barr thought that NUR2 was the default rule for utilities not involving those provisions that are those facilities that are covered by
I will let Ms. Carville answer that one, but just looking at it now, I agree that one may be the default. I don't think that it's appropriate to have 2 rules that have applied a different set of criteria on abandonment.
Yes, so. And from a legal perspective, the more specific rule would normally apply. Is that
correct?
And that might be the intent of the words not provided for by another rule in this table. Yes, okay. Well, let's see what Ms. Carville comes up with. The second matter, and it's something I just want to signal that some further questions to Mr. Stevenson. In your 7.4 and 7.5, when you're referring to the combined Australia-New Zealand standard, you talk about a very detailed regime, and then 7.5 subject to a robust abandonment process. We need to understand what that process is as it's stipulated by the standard.
Yes. Okay.
It's one thing to know what Greymouth do, but that's not what the rule is saying. It's saying that you're bound by the standard. So will Mr. Stevenson take us through that?
Mr. Stevenson's evidence generally outlines it, but he doesn't provide you with the standard, and it may be something that we can provide in to you as evidence. It's always difficult to get parts of the standard in hearings like this, but I think we could attempt to try to provide you with that particular part of the code so that you can see it yourself. So his evidence does outline it, but he's not giving you a direct quote.
Right. Your friend, Mr. Quinn, attempted to provide some evidence on this also, and he provided a flowchart of the abandonment process that may or may not have come from the standard. I'm not sure.
Which we couldn't read, so I think he's provided. And just signalling, there's some issues with the readability of quite a bit of Mr. Stevenson's.
Yes, I took your comments on board. So Mr. Stevenson is handing up for you clearer and larger versions of all the flow diagrams in his evidence. And as I understand it, the flow diagrams are not the words of the standard. So we will still endeavour to get you the words of the standard. There's a little bit of issue with sort of the intellectual property and the payment of fees for standards. So we'll just have to see how much of that we can make available to you.
I understand that, but whatever you can provide would be helpful. Thank you.
Yeah. I think just on that second point, I guess we need some commentary alongside what the standard requires so that we're not interpreting it or misinterpreting it.
Yes. We will provide you with the standard, and Mr. Stevenson will give you the plain English version should it be required.
Yes, I think Ms. Cannon would appreciate receiving that. My third point, Ms. Price, is just a very minor one, and I just want to check at your 7.8, that legal principle in the Whakatane Council decision. Is that the same principle that I asked you about earlier about wastage in terms of the buffer distance?
It's the same case. And so it's just a slightly different point, but from that same case. So
and drawing on the same principle, but achieving an environmental outcome, in this case, a buffer distance.
Correct.
You go for the one that achieves the outcome without undue.
Correct. You don't layer and layer and layer. Yes. That's basically what the court was saying.
Thank you. Thank you, that was all.
Okay, now we come to a new piece of legislation that got passed last week. And I don't know if anyone's addressed you on it, but I thought I would, which is the Crown Minerals Decommissioning and Other Matters Amendment Act. In addition to all of this, we have another layer, which is the Crown Minerals Amendment Act, which aims to strengthen the law regarding to petroleum decommissioning activities. Decommissioning is the process, as they've defined it, of taking petroleum infrastructure and wells out of service. It generally involves, and I'm quoting here from the report, plugging and abandoning wells, removing or leaving infrastructure in place and restoring the site if needed. The Decommissioning Amendment Act introduces a number of provisions to mitigate the risk to the Crown and other third parties of having to carry out and fund decommissioning of petroleum infrastructure. While the Decommissioning Amendment Act does not appear to apply to all petroleum pipelines, I submit that the Decommissioning Act and the recent committee report provide useful context to this hearing. The report explicitly stated that leaving infrastructure in place should be available and that removal may have increased environmental effects compared with leaving it in place. The committee recommended that a new subsection to give effect to this concern be inserted, enabling a permit holder to apply to the Minister for permission to leave the infrastructure in place where criteria prescribed in regulations were met. The Decommissioning Amendment Act includes a new subsection at section 89E4, which provides, despite the earlier subsection, an item of infrastructure left in place in accordance with a process set out in the regulations must be treated as having been decommissioned. Therefore, for Greymouth to decommission one of its pipelines, it has two regimes potentially applying: the abandonment process under the Australian-New Zealand standard and the Decommissioning Amendment Act. It is submitted that adding a third regime requiring resource consent to leave a pipe in situ is not appropriate in these circumstances.
I'm pleased you've addressed us on this. I came across a reasonably alarmist advisory statement from Chapman Tripp.
Yes, I saw that too.
Yes. Just last night, and I sent an email to David and said, hey, this looks like it's probably applicable. So we have not been addressed on this. So appreciate the time we've taken to look at this for us. So yeah, just I suppose a question about
So the concerns from Chapman Tripp don't relate to what I've just addressed you on. They're really about the liability that comes from the Amendment Act. And what the Amendment Act is trying to prevent is entities with permits basically liquidating, exiting the country and leaving the Crown, or the public, if we'd like to put it that way, the New Zealand taxpayer, with the responsibility to properly decommission assets. The clauses that were causing Chapman Tripp concern was that it was retrospectively making directors in the past of previous entities that may have owned that particular permit criminally liable. So if you had been a director of a company in the 1990s that had that permit sold on multiple times and the current owner was liquidated, you were still on the hook for criminal liability because you're caught in a chain. And we've had similar analysis in the past with contaminated site liability, and the way the courts have interpreted that is to not allow it to keep going back through and catch directors of companies from decades before. But this is the first time we've ever had legislation in New Zealand where a director who at the time that they exited, 10 years ago from being a director, thought that all their liabilities were dealt with at the time, now has something that is a new legislation putting retrospective liability onto them. And that is relatively astounding.
Yes. Look, and the other question I had, thank you for that explanation. You're saying that it's not, maybe not relevant to your client because of the way the definition of limited to infrastructure used for exploration, mining and processing, not transmission. Is that where that
Correct.
comes from?
So it's aimed at those that are extracting from a permit, as opposed to the distribution.
Thank you.
No questions from me, Ms. Price. You'll be relieved.
Okay, thank you. So then we come to the section on the permitted pipeline pressure threshold, and Mr. Stevenson is definitely going to address you on this in quite a lot of detail. So my submissions are really just highlighting what's to come. Greymouth seeks a permitted activity threshold of 13,600 kilopascals gauge pressure for liquid petroleum and gas transmission and distribution pipelines in the rural production zone and major facilities zone, as opposed to the 2,000 kilopascals in all zones in the proposed plan and as recommended by the Section 42A report. The evidence for Greymouth demonstrates that a comprehensive regulatory framework outside the RMA applies to petroleum pipelines, including their design, construction, operation, maintenance, suspension, and abandonment, including with respect to public safety and changes to risk profiles over time. The Network Utilities Section 32 report acknowledges that the operative district plan recognises that the pressure of pipelines is managed by existing legislation, regulation and standards to ensure that they are constructed in a manner that ensures they are safe and will not adversely affect public health. Mr. Stevenson's evidence is that potential public safety effects associated with 13,600 kilopascal pipelines are similar to the effects of pipelines up to 2,000 kilopascals, which are permitted under proposed NUR 19, and that such effects are managed comprehensively outside the RMA. Mr. Stevenson and Ms. Carville's evidence is also that the other potential environmental effects, such as earthwork and transport effects, associated with pipelines up to 13,600 kilopascals are also similar to those for pipelines up to 2,000 kilopascals, contrary to the concerns expressed in the Network Utilities Section 42A report, and are managed by other rules and standards in the proposed plan. In other words, the pipelines sought to be permitted by Greymouth would have effects that are comparable to pipelines that are already permitted in the proposed plan. In addition, Ms. Carville and Mr. Stevenson have identified no restriction on gauge pressure in the operative district plan, and Greymouth has not identified any evidence there are material issues with the current regime. I submit there is therefore no compelling basis for the 2,000 kilopascal threshold in the context of the proposed plan. Providing for pipelines of the pressures sought by Greymouth in the rural production zone and major facility zone as permitted activities is appropriate. Potential effects are already comprehensively and appropriately addressed outside the RMA and or through other provisions in the proposed plan and regional plans, such as the earthworks rules. As with the office's recommendations with respect to the removal of underground pipelines, requiring consents for pipelines over 2,000 kilopascals is therefore unnecessary, duplicative with other legislative regimes and is inefficient. The Environment Court's comments in that Royal Forest and Bird Protection Society case also apply in this context. Finally, there is also the perverse outcome that upgrading of pipelines of more than 2,000 kilopascals for the purposes of safety improvements would be caught by NUR 19. Shall I move on to the conclusion so you can get questioning Mr. Stevenson? Greymouth seeks the relief sought in Appendix 1 to Ms. Carville's statement of evidence. In summary, my principal submission is that Greymouth's evidence demonstrates the provisions sought by Greymouth give effect to the applicable higher order planning instruments. In terms of Section 2 of the 32 of the RMA, the objectives proposed by Greymouth are the most appropriate means of achieving the purpose of the RMA, and the provisions proposed by Greymouth are the most appropriate way to achieve the objectives, and the changes sought by Greymouth will appropriately provide for the regionally and nationally significant activities undertaken by Greymouth and others while appropriately managing potential adverse effects. Thank you very much.
Just one from me, and just to repeat the earlier question in relation to your 9.2a, the higher order planning instrument direction for the word avoid.
Yes.
Yes.
Thank you, Ms. Price. Very helpful, and looking forward to hearing from your witnesses.
Okay, we're leading off with Jason Stevenson. Jason, have you come forward? I can hardly see in this little league. Yes, okay. Jason, before you read from your evidence at the executive summary, would you like to hand up the maps and photos and larger flow diagrams?
So that's kind of a larger A3 version of those flow diagrams. So hopefully they'll be real. Apologies, I've only brought one copy for you specifically.
Thank you. Not that I've actually got very good close sight. It's not as though I'm on the opposite.
It is. Yeah, I appreciate it's quite good that Karen did cover that. It's a bit of a challenging space to, in the interest of efficiency, I suppose, is to give you the relevant parts of the standards, but feeling, yeah, from an intellectual property, there's some challenges there. So
really appreciate that, Jason. It's excellent.
Yes, so just some photos of the kind of context that we'll cover as we sort of, I think we'll do some more question time.
Thank you. Yeah. Go over your question.
Oh, yeah.
I've got another set there.
Oh,
the photos.
Oh, do you need to refer to them, or?
I've got my own set.
Okay. You don't have them in the soft copy?
I do on my tablet, but not just directly.
Okay, because the
Karen has.
Karen, I wonder, because the people on Zoom and others can't see these, we're bringing those up on the screen. Any photo photography. So is there a way we can get the hearing administrator a copy of these that we can actually put up on the screen?
Yes, I'll just find it and so this is emailing through to Christine now.
Right. So we'll just take a couple of minutes to organise that. We'll take a breather while it's been done.
Yeah.
Oh, it's photos or after.
Oh, yeah,
Photos at the bottom, okay.
Okay, I just.
There we go. Thank you, Christine.
Yeah, that's the
Okay, Mr. Stevenson, if everyone's ready down there.
Yes, thank you.
Would you now like to read your executive summary beginning at paragraph 6 of your evidence, please?
Thank you, Karen, and thank you, commissioners, for the warm welcome. So, yeah, providing my evidence in relation to the rules in new Rule 2 and Rule 19. So, a comprehensive regulatory framework outside the RMA applies to pipelines, including their design, construction, operation, maintenance, suspension, and abandonment, including with respect to public safety. Medium scale pipelines up to a design pressure of 13,600 kilopascals pose similar risks to pipelines with a design pressure of 2,000 kilopascals, which are permitted under the proposed Rule 19. The current regulation of the industry, including through the Health and Safety at Work Act, Health and Safety and Employment Regulations, regulatory oversight by WorkSafe, and third-party certification, requires adherence to the industry standard of AS/NZS 2885 pipelines, gas and liquid petroleum, in particular Part 3 for operations and maintenance, which includes abandonment of pipelines. NZS AS 2885 include the range of requirements before abandoning the pipeline, including regarding the potential environmental effects.
Thank you, Mr. Stevenson. Could you now explain the photographs that have just been provided to the panel?
So just to, my understanding was you're sort of trying to understand a bit of context between what does a 2,000 kPa pipeline look like relative to the 13,600.
Yes.
And so this is Inglewood delivery point, just on the outskirts of the Inglewood township. And this is basically a regulating station where the natural gas pipeline pressure drops down and then goes into the town distribution system. And so on the left-hand side of the right-hand side of that picture is where it's now the 2,000 kPa pipeline and then being distributed into the township. And then what you will find is as it goes into the township, and it starts out as a 3 or 4 inch line, and it's starting out as steel, but once it goes into the individual roads and individual networks, it will then drop down to smaller polyethylene pipe, yellow pipe you would see.
So 3 or 4 inches, is that the 15 millimetre?
Sorry, yeah, so I'll try and stick to metric, maybe.
Well, like a
Yeah, 4 inches, 100 millimetres.
100, yeah, okay. Thank you.
And then the next picture I've shown there is this is one of our well sites, and this is in the foreground of the picture is the piping on site, and then the left hand side at the back there is basically our again 100 mil pipelines, which are 13,600 kPa entering the ground and then going out to the left hand side of the picture. So I suppose from the outside, arguably they look very similar.
Yes. Oh, that's helpful.
And probably and affects the key difference really is the wall thickness of the pipe that you see. The next picture is really just the other end of this pipeline, and shows at our production station where the two pipelines of interest really come into the station, and it's sort of on the left hand side to the middle, kind of here where the mouse cursor is currently positioned on the screen there, is where the pipelines are coming in from below ground to above ground, and then it again goes into our sort of piping that is then delivering it into our processing facility.
We visited this
plant. Yes,
Yes. It was a fascinating day, wasn't it, David?
Yeah, that's quite good to provide you some content. Right.
Thank you.
And if we, maybe just be happy to carry on with the photos just to provide more sort of context. This is sort of a pipeline construction in progress. So usually, we're generally in a rural farmland. So this is essentially a farmer's paddock from our Turingi B site in the background. We lay out we survey the route to identify where the line's going to go, which will be sort of some sort of markers in the ground in front of that ute on the left hand side, and then the guys lay out the 12-metre lengths of steel pipe, which are already pre-coated. They lay them out and they get them ready, and then they come along, they weld them together, and then once they're all welded together, then they actually excavate the ground and they lay them in the ground, and then once they're laid in the ground, they'll then cover them again with that film. The next picture sort of just shows, so that's pipes, two 100 nominal, 2 100 millimetre pipes that are 13,600 kPa. That the farmer pit, we usually strip the topsoil as the first sort of layer, and then and so it's to install 2 pipelines. It's sort of about 700 mil, 700 mil that we sort of width that we take. Take away, put the topsoil on one side initially, and then we'll excavate the clay layer. And then if we go to the next photo, which sort of shows the process of once the clay's been put up to one side, the pipes are sort of gently lowered down into the bottom of the trench, which is about 1.2 metres deep.
Well, pretty flexy, aren't they?
Yeah, they are quite flexible. Yeah, over long length. And then the next photo kind of shows a demonstration of, partway through the backfilling process, so showing the depth of the trench where the pipelines are buried. And in this particular photo, there's two 100 on the bore pipelines, and the red sort of line there is a conduit that we've got fibre optic cable communications running there. And then just kind of showing the backfill in progress, and then we have 2 yellow marker tapes sitting above the pipelines, and there's a red marker tape for the fibre optic.
Great. And is there some bedding material put on the bottom of the trench, or just
it's part of depending. We're pretty fortunate, I suppose, with Taranaki clays. It's quite gentle, and doesn't pose a risk in terms of damaging the pipe. But if you kind of go through any rocky metalled areas, we have to substitute that with sand or a soft material to make sure that you don't damage the external coating.
And the external coating is made of
Polyethylene.
Okay. Thank you.
Okay, Mr. Stevenson, I read out to you that the panel had a number of questions about the potential effects of the different pressure pipelines in the Tuesday hearing. And so I've asked you to specifically address a number of issues, including public safety, adverse effects on the environment, earthworks, traffic effects, and effects on significant natural features. Could you please address the panel on these issues?
Thank you, Karen. Now, with respect to public safety, are we okay to take I suppose the evidence that I've presented here, sort of I feel comprehensive covers that. Yes. Are we okay to take that element as read, and maybe see if there's any particular questions?
Yes, no, I thought that was pretty thorough, so thanks for that.
Okay, that's good, thank you. With respect to effects on the environment, with respect to effects on the environment, essentially similar controls apply to public safety. With respect to the primary, I suppose, thing we're interested in is making sure that we're not having damage to our pipeline to cause a loss of containment. That would drive issues around public safety. The same controls apply to preventing the loss of containment that would result in effects on the environment from the operation and maintenance of the pipeline. And then probably over and above those safety controls, we have emergency response procedures that are in place to mitigate any effects that could happen to the environment. And I think on reflection, possibly an element that distinguishes sort of our pipelines relative to the lower pressure pipelines within town, or within lower pressure, the 2000 kPa pipelines. Our lines have quite, probably relatively short distance, fixed volume, and have safety equipment at both ends of that pipeline. So if a leak does occur, as part of that emergency, we would isolate that pipeline, and we have facilities to safely depressure that pipeline via our production station that you would have visited. So we can quite rapidly minimise and mitigate any release and environmental effects of those lines. With respect to the earthworks effects, as I've sort of demonstrated in the photo there, our pipelines are buried to a minimum depth of 1.2 metres. And this, relative to the lower pressure pipelines, which may only be buried to, say, 600 millimetres or 0.6 of a metre. The width of the excavation to bury a pipeline will be similar for a single line, which would be approximately about 400 millimetres wide. So, as I sort of said, whether it's a 13,600 kPa pressure line or a 2,000 kPa pressure line, and are both 100 millimetres, the width of the excavation you need is going to be similar.
Yes.
Based on our average pipeline length of 2,000 metres, the volume of soil excavated would be 480 metres cubed for based on that average pipeline length of 2,000 metres, volume of soil excavated would be 480 metres cubed for a low pressure line with that with only effectively half the depth. Our line would require, with the extra depth, would be 960 metres cubed. The Regional Council guidelines for earthworks and control of stormwater specify that a consent is required if the volume of disturbed material is greater than 3,000 metres cubed. So therefore, irrespective of the design pressure of the line, both kind of examples in this case don't trigger don't immediately trigger they can be triggered some. Yes. We typically opt to install a minimum of 2 pipelines between our sites to future-proof the connections. This by looking at this one, this would increase the volume of earthworks. So it would be a 700 millimetre wide trench, and the volume of earthworks would then go up to 1,680 metres cubed. But this is still below that 3,000 metre guideline. In respect to traffic effects, particularly associated with construction, the effects would largely be similar. Construction of both line pressures would require transportation and offloading of equipment, particularly excavators, to undertake the trenching. The pipeline materials will have to be transported to the location. Vehicles and personnel need to be transported to join and weld the pipelines and lay them in the ground. The high pressure pipeline would require slightly more light vehicle movements to cater for the additional non-destructive testing, coating, inspection and supervision requirements. And effects on areas of significant natural features and landforms or values, interests of associations of importance to mana whenua. Largely a consequence, so these would largely be a consequence of the earthworks required as part of the installation process. Similar effects would occur irrespective of pipeline pressure. And these are currently, we address these through our land liaison and consultation processes.
Thank you very much, Mr. Stevenson. Could you now answer any questions from the panel?
Thank you.
Mr. O'Mahon.
Yes, thank you, Stephen. Thank you for those explanations. I think they're really useful, and the photographs. Well, I'm a very visual person, so
yeah,
I know the images of pictures tells 1,000 words, 1,000 words, and in this case it is. I guess a couple of things that arise for me, and also for the benefit of Ms. Cannon. The earthworks effects, I'll go back a step. In your role in terms of pipelines, are you involved in route selection for U1? Okay. And does that extend to involvement of the consenting process where a consent is required under the RMA?
Yes, we as well as Rebecca.
Yes. Okay. Okay. So the reason I've asked this is one of the relief points sought by Greymouth and covered in Ms. Carville's evidence is to strike out the words relating to underground transmission lines related to within or on a natural water body. So, and so obviously there might be instances where pipelines need to go across water bodies, either using an existing structure or the addition of the structure. So how common would that be in your experience?
It's very common, I think. It's pretty much due to the nature of Taranaki topology around the mountains, and it's very difficult not to if you're going 1,000 metres, not to come across a drain, a stream, and a named tributary.
Yes. Yeah. And so, what's the method there? Is it where there's a structure already, like a culvert or a bridge? Would you attach to that?
We would, wherever possible, we'd always go underneath to maintain that level of cover from a safety perspective.
Yes.
So that's probably the primary consideration from safety.
Yes, and that would trigger a regional consent in either over the bed of a river or through a body. Yes.
And where the detail then goes is kind of working through, do we so that the two main techniques is to either underbore, so using a drilling techniques under, or to kind of essentially what we call excavate, which is to basically trench down and then under the stream.
Yes, and a former life I did a lot of work for a telecommunications company, familiar with trenching and drilling and mole ploughing and those sort of techniques. So yes. Okay. Right. aside from that, any trenching on solid ground, Greymouth don't appear to have, well, I'm not sure. Are you aware whether Greymouth challenged the earthwork provisions in other parts of the district plan? Are you happy with those provisions in terms of carbon volumes?
Yeah, so we had submissions
Yes.
back in hearing. Yeah.
Hearing on
Yes.
possible.
You were involved.
No.
You
No. Okay.
well, got the continuity
We
there.
have to relate to some of the carbon following
Okay.
related rules, which is
Yes.
Ms. Carble again presented
Yes.
evidence.
Okay, no, the reason I asked that is Ms. Price had said in her evidence that there are that the potential effects associated with these are already covered through other provisions in the proposed plan and the regional plan, including, and she specifically said, earthworks rules. So I'm just trying to ascertain what the position of Greymouth was on that.
Awesome. Maybe where you're kind of going is, no, so in effect, when, what you're saying is, when we do a pipeline, are we likely to cross some sort of water body?
Yes.
And when I say yes, effectively, we're pretty much, it's pretty high likelihood that we're always going to need a resource consent from the regional council.
Yes. And you're likely to trigger some earthworks rules, depending on the outcome of submissions to those earthwork rules from here on forward.
Actually, depending on obviously the scale of the earthworks.
Yes, that's good. Okay, that's all from me.
Yes. I have a couple of clarification points, really because I'm interested in all these technical matters and I like little learning as we go along from experts. So when you talk about paragraph 10, dry gas is where natural gas has been dew pointed. Can you just explain what that means?
Yeah, sorry, that is probably a bit of a, so that is its water content and its liquid content has been reduced.
To dew point.
Yeah, so
a measurement, isn't it?
Yeah, to a measurement, and I suppose the inverse would be when you cool down the gas,
yes,
and you lower its temperature,
yes,
the dew point is the first point, then liquid would start.
Yes, okay.
So yeah, yes. So the NZS 54, so it was the New Zealand standard for all export gas, that, all producers and transmission network. We have a 2 degree dew point limit, so the gas can get cooled to 2 degrees before any liquid starts appearing.
All right.
Which is essentially a safety aspect at the other end.
Sure.
Making sure that, so.
Thank you. And the other learning I need is, I think it was, just 66, product protection. Just talk us through what that entails.
Is applying. It is applying essentially electrical current to counteract the galvanic corrosion effects that can occur in the soil.
Yes.
So basically, by applying that electrical current to the steel, that basically the galvanic corrosion, I suppose, works its way through that electrical thing rather than attacking steel at the pipe.
Right. So that is needed both when you're operating and also when a pipeline abandoned.
I suppose the abandonment process and particularly that paragraph from AS 2885 referring to cathodic protection. So normally you would probably at abandonment you would turn off that cathodic protection and the pipeline would be left in a natural state.
Yes.
But if there is something particularly important that that as part of that risk assessment and that process of determining what the abandonment plan what is the content of that or the method of that abandonment, if there's a section that is defined, no, that cathodic protection must stay in place, that there's basically saying you need to maintain that cathodic protection for the foreseeable future.
So is that just by putting some sort of power?
Yeah, power basically.
line
Yep.
down in
At
there?
very low voltage.
Low voltage, yes. Okay, that's helpful. I have another question, which is more of a company question, so you might need to sort of both think about this. Have you had the opportunity to read the evidence of Mr. Holswich, Ms. Hokoparau and Ms. Marco?
Yeah, briefly.
You have. So my question really is around interface with sites of significance to Maori. Also, just the cultural values of particular areas. And I'm particularly interested in the method and the relationship that Greymouth has with Hapu and iwi in the areas of operations. We've read from those statements that there seems to be there's evidence about a wish for relationships and involvement and engagement to be stronger than it has been in the past. So really just wanted to get a feeling for how Greymouth deals with that, particularly around route selection, being aware of issues and problems maybe, and particularly given the new MPSFM, and we're talking about water bodies and the Hapu experts, the planning experts, don't seem to have a lot of faith in the current regional council processes. You know, reasonably old plan, particularly reflective of more modern practice around companies' engagement with their mana whenua in the areas. So yeah, can you just take me through the approach of Greymouth and how you deal with that element?
So if the consent is required, usually regional council, as Jason touched on, if it's a pipeline that covers a distance that's likely to cross the stream, then we require regional consent for the disturbing bit of a stream. We do consult with the relevant iwi. Basing on my experience with Greymouth, we've had a recent pipeline that was consented in the past year, and it's in Ngāti Wahi's road area, and we consulted with them. What I consider to be an early stage of the project. We had them involved in so the route that they had input into where in a certain area where the pipeline would cross the stream and things like that, to take into consideration their cultural values they have with streams, and in particular the new MPSFM, and the need to give more effect to those kind of considerations. And then during the construction side of it, we always have cultural monitors present for the stripping of the topsoil, involved in that aspect as well.
And generally we always have once or twice a year we sort of have a bit of an update.
Yeah. So especially in our more active permits, we're having regular catch-ups with relevant iwi.
But where's the relationship held? Is it within the company? Is it with the land liaison officers, or is it with senior managers or CEOs or anything like that?
So day-to-day kind of communications with our land and consenting team.
Yes.
We do have a iwi morning tea where managers and our COO meetings as well. So it does have that interaction at a higher level as well. But day-to-day operations and communications is with myself or others in the land and consenting team.
Okay. Yes. Just one final question on that. Around route selection, I do a lot of work for clients around the country in the infrastructure area, and early engagement, even at that route selection. When you start to think about a project, so you get a good understanding of particularly sensitive areas, again, in my experience, all me, it's a lot of value. And so it's probably, would you say it's sort of like an evolving type process?
Yeah,
which you're open to,
yeah, definitely an evolving process, and always looking to improve those relationships and do keep down what we require. In terms of research, obviously, we look to avoid any such significant money and things like that as well. So our consultation involves those kind of discussions as well.
We're dealing with this difficult area where not all sites are known, certainly known publicly through mapping or archaeological sites. Some of them, it's held by individual and then just different information bases. So we again don't like the word grappling. We're really thinking hard about in the significant natural area space, for example, these areas that aren't mapped that may still get affected. And also in the section 6E sort of matters around Tonga and sites of significance. So
our relationships with Area Hapu obviously look to work with them in terms of projects and any unscheduled features that they might be that we're not aware of.
So it seems to me that no matter what's written in the plan, and I'd be interested in your thoughts on this, that relationship, active relationship, is going to achieve a lot in that space of uncertainty where, and I know corporate companies, they like the certainty of mapping and the ability to get on with things, but even particularly in the North Island, particularly Taranaki, there's these, long history, obviously. So it's good to sort of talk about this and understand where the company is. I haven't had the same conversation with many of the other submitters in the space, just because I've really been reading recently the EV evidence on this matter, so perhaps you're a bit more on the hot seat than normally, but I think it's a good discussion to have. Appreciate your thoughts.
Yeah, I think it's always a room that can be improved on, and even recently, I think we both participated in the annual review that we had with the ministry, and it was a topic that from the ministry perspective as well.
All right, thank you. A little bit off, well, not off topic, it is on topic, because it's these matters that we're thinking about in terms of the relief sought from the Hapu in terms of their experts. Look, that's everything I have for you, Mr. Stevenson. Appreciate the additional aid memoirs for us in terms of the photos and the blow-ups of those tables. Thank you very much. David, do you have anything else? No. All right, so I think we're moving to Ms. Carville. It's do you want to carry on?
Happy to.
Happy. Yeah, let's just carry on and we'll work through your evidence, Ms. Carville. Thank you.
Thank you, Ms. Carville. Could you read your executive summary beginning at paragraph 11 and then answer the questions from the Commission? Thank you.
Good morning, everyone. I was actually going to start at paragraph 12, Karen. Happy to read paragraph 11. I present this planning evidence on district-wide matters in relation to the network utilities and transport chapters on behalf of Greymouth Petroleum. So most of my evidence relates to network utilities, and that's what I'll start with. Greymouth's activities include the operation and maintenance of a network of pipelines, and therefore Greymouth made submissions and further submissions into the network utilities provisions of the plan. The submissions were generally supportive of the provisions on the basis that they enable and provide for network utilities while appropriately managing adverse effects. Where the submissions and further submissions oppose the wording in the proposed plan, I've considered the section 42A report and provide suggested amendments that I'll talk through now. So starting first with policy new P4 relating to managing adverse effects of network utilities. This policy, in my view, includes an absolute requirement for network utilities to adopt sensitive design to maintain the character and amenity of the surrounding area. My analysis is that neither the planning framework of the proposed plan or the wider planning framework require that network utilities avoid all adverse effects on character and amenity. On this basis, I have proposed amendment to the policy to provide for avoiding, remedying or mitigating adverse effects through use of sensitive design where practicable. I consider this qualifier as appropriate in this situation, given the policy framework and the regional policy statement and the proposed plan, which recognise the critical importance of network utilities. Obviously, was listening to the discussion earlier about whether a definition of practicable in the plan may be useful. I agree with the comments made by Ms. Price in relation to that. I think a definition is always helpful in a plan where there may be interpretation questions. There was also some discussion about whether it was use of this qualifier was best placed in objectives, policies or matters of discretion. I understand that Ms. Price is going to come back to you on that, but from my perspective, I have, I guess, a view that it could be sensible or appropriate to use it in any of those places, depending on the context. But that most typically I would expect to see it in policies and matters of discretion. I think that, as Commissioner mentioned, objectives sort of set an outcome, and that objective would be informed by the following provisions in the hierarchy. But there may be circumstances where it would be appropriate. But certainly in this case, where I've suggested it in the policy, I think that is a very appropriate place to use a qualifier of that nature.
Carmel, have you seen qualifiers defined in plans before?
I haven't. I'm kind of tempted to go looking for it, but trying to stay focused on.
So would you agree as a practitioner that if you are looking at a consent and policies and matters of discretion where qualifiers are used, that particularly where courts define something, it would be pretty helpful, wouldn't it?
Yeah, certainly my first instinct when you mentioned potentially defining it was I've never seen that before, and I wonder why not. It certainly seems helpful. I'm a big fan of definition sections and plans, and it certainly makes a lot of sense to me, particularly as you say where the court's given what is really a very helpful and sensible sort of set of items that you could work through.
Yes.
Yeah.
Yes. So I think what we'll do is we'll let Mr. Stenner and Ms. Cannon ponder that, and probably needs to be talked around obviously with the rest of the team, but it's just something to ponder. I would have thought there was scope with, well, that's a question, obviously. No specific words have been proposed like that, but we have to think about that quite carefully. So thank you for that.
Yep, no problem. Turning to policy NUP8 in relation to managing adverse effects of, on network utilities of new sensitive activities. This policy requires that reverse sensitivity effects are minimised, and greymouth submissions sought that such effects should be avoided. The reporting officer has recommended retention of this policy with no amendment, including that the wording of policy P8 strikes an appropriate balance between the protection of network utilities from adverse effects of other activities and enabling the efficient use of land. While I concur with the reporting officer that it is valid to balance the protection of network utilities with enabling the efficient use of land, Section 5 of the RMA requires enablement of people and communities to provide for their social and economic well-being, and also requires avoiding, remedying or mitigating any adverse effects of activities on the environment, which includes reverse sensitivity effects. Therefore, there is support in section 5 of the RMA for protecting existing activities on the basis of the contribution they make to social and economic wellbeing. And then I've considered the policy within the broader framework of the Network Utilities chapter objectives, and also in relation to the hearing panel's interim guidance, noting the comments that the Commission's made earlier. In relation to that wording of the new objective, which seeks to ensure that reverse sensitivity effects are avoided. Firstly, I guess objectives NU 01 and 02 recognise and provide for the important role network utilities play, including providing significant positive effects. This, in my view, sets the context for placing a high priority on protection of network utilities. And objective NU 03 seeks to ensure that network utilities are not constrained or compromised by other activities. And I might just take you to paragraph 71 of my evidence there, where I talk about that in a little bit more detail. I guess the amendment sought to policy 8 is consistent with objective 03 in my view. In particular, the avoidance of reverse sensitivity effects is consistent with the objective of ensuring that network utility activities are not constrained or compromised. And in my view, a requirement to only minimise reverse sensitivity effects would not enable objective 03 to be met. I guess on that, it's something that I talked about also in my evidence in hearing 4 in relation to noise effects and reverse sensitivity in that context. And in my evidence at that hearing, I had proposed some wording that included after not avoid reverse sensitivity effects that result in undue constraints on network utility activities, and potentially a similar approach could be taken here in terms of just really tying that back to the objective. And I also noted your comment earlier, your query to Ms. Price in terms of higher order documents. I understand Ms. Price is going to come back to you on that. There's nothing that's leapt to mind that I can point you to specifically today. The only thing I would note is that the regional policy statement does identify effects on infrastructure from sensitive activities as a regionally significant issue. So that is sitting in there as one of the key issues in relation to infrastructure and the RPS. So on this basis, I consider that the amendment to P8 to include avoid and to remove the words where necessary is consistent with the broader policy framework and is appropriate. In relation to network utilities rule NU R2, the rule requires that structures that are no longer required for network utility purposes to be removed within 6 months of becoming redundant. The reporting officer acknowledges that there may be some situations where abandoning infrastructure in situ leads to better environmental outcomes. Notwithstanding this, the reporting officer concludes, on the whole, it is expected that removal of redundant infrastructure leads to better environmental outcomes, particularly in relation to above ground infrastructure. Potential effects associated with remediation and leaving in situ are comprehensively addressed through compliance with the standard that we've been talking about this morning, and therefore it is my opinion that further regulation of this activity through the district plan is not necessary and would be inefficient. The network utilities effect standards and other applicable rules and standards in the proposed plan and the applicable regional plan requirements would still apply. I've suggested wording which incorporates the 2-year timeframe recommended by the reporting officer, permitted activity status for removal of above and underground structures, and permitted activity status for underground structures that are remediated in accordance with the standard. Inclusion of reference to the standard in the rule provides greater certainty than the wording that was originally requested in the Greymouth submission, which just referred to remediation in accordance with best industry practice. Just referring to the query relating to the do we need the change in Rule 2 as well as in Rule 19. I just had a quick look at that while we were talking, while the other evidence was being worked through, and my initial thoughts are that it is still required in R2 because the wording, all structures that are no longer required, sits in the table underneath R2, and that table applies to R1 and R2. And R1 doesn't have the qualifier not provided for by another rule in this table. So R1, the wording is operation, maintenance and repair or removal of above and underground network utilities and ancillary vehicle access tracks. So just that's my initial thinking, just looking at it in the background while we were talking. Happy to give that some more thought and come back to you on it, but that was my initial thinking, is that it potentially is still required in that spot. Okay, and just turning lastly on network utilities to Rule R19 in relation to the gauge pressure matter. So that rule requires resource consent for pipelines with a gauge pressure of over 2,000 kilopascals, and as you know, Greymouth sought that the permitted activity threshold be amended to 13,600 kilopascals. The reporting officer recommends rejection of Greymouth's submission, concluding that allowing the installation of pipelines up to 13,600 kilopascals could generate adverse effects on the environment, and the reporting officer listed potential effects on public safety, large-scale traffic effects and potential effects on areas of significant features and landforms or values, interests or associations of importance to Mana Whenua. Based on the evidence of Mr. Stevenson, it is my opinion that potential effects on public safety of pipelines in rural settings and the major facility zone up to 13,600 kilopascals are similar to pipelines up to 2,000 kilopascals, and therefore there is no basis for requiring resource consent for pipelines in rural settings up to 13,600 kilopascals in order to manage potential effects on public safety. There is no restriction on gauge pressure in the operative plan, and no evidence is presented in the Section 32 report that effects on public safety have arisen as a result of the current permitted activity status that would warrant the introduction of a rule requiring resource consent for pipelines over 2,000 kilopascals. Overall, I consider that it's appropriate to provide for pipelines up to 13,600 as a permitted activity in the rural production zone and the major facility zone, as potential effects on public safety are similar to effects of pipelines up to 2,000 kilopascals. Potential effects on public safety, including from changes to risk profile over time, are comprehensively and appropriately managed by legislation, regulation and standards outside of the RMA, and other environmental effects associated with pipelines up to 13,600 kilopascals are similar to those for pipelines up to 2,000 kilopascals and are managed by other rules and standards in the proposed plan. Turning now to transport, so obviously Greymouth's activities within the district include traffic generation to and from sites, as well as vehicle movements associated with site maintenance and overall efficient operation of the sites. Greymouth therefore made submissions and further submissions in relation to the transport provisions. In relation to policy P17, which relates to the type and level of traffic using the transport network, this policy includes absolute wording requiring high traffic generating activities to locate on arterial and collector roads. This is not practical for the majority of oil and gas activities which occur in rural locations that are typically accessed by local roads. I consider that the amendments sought in the Greymouth submission help to provide guidance to the plan user, including through use of the terms where practical and where feasible, which help to indicate that these options should be prioritised where possible. All I was going to cover today, so happy to take any questions.
Commissioner McMahon. Christine, I wonder whether we can have Jennifer front and centre, just a little box on our right hand side at the moment. Did you just change the?
Oh, sorry, I should have changed that before.
Right, you're about the same size as the rest of us in the room, Jennifer, so that's,
Apologies, sorry.
that's really good, thank you.
Good morning, Ms. Carville. Thank you for picking up on my questions as you went through your executive summary. Lots of ticks in my margins. And that just leaves me with a couple of additional questions. First relates to the higher order reference point for the word avoid. You've pointed to NUO3 within the objective level with the focus on network utilities not being constrained or compromised as the basis for the policy to give effect to that objective. So thank you for that. There's been a proposed or a recommended change to that objective by the reporting officer to change the wording, which currently reads other activities, to incompatible land use, subdivision and development. Are you comfortable with those changes?
Yep, I'm just double checking my evidence doesn't say something different from that, but yes, I think so.
The objectives
Yes,
also
yes,
change
yes,
to refer to safety also, yes.
Yep, that's correct. Yes, my evidence confirms that I concur with the recommendations of them. So.
Okay.
Yep.
So what I'm getting from you is that the policy, the basis for the change to policy really don't need to go much further up the line other than the objectives for the network utilities to seek guidance. Is that what you're saying?
That's correct. I think it's also supported by obviously the other parts of the plan in terms of the interim guidance provided by the minute and
yes,
the overall general support. But yep.
Yes, you did refer to the RPS and an infrastructure objective for policy. I just didn't quite get that. That was dealing with this theme also of protection and avoidance.
That was just a comment that the RPS includes identification of significant issues for the region and identifies as one of those significant issues being the potential effects, impacts on infrastructure from other sensitive activities.
Yes, Ms. Rank yesterday pointed us to the RPS also, and she focused on a particular, I think it was an objective, IENF 1 or 3, I can't recall. It would be useful to know whether you are specifically relying on the same provision. I'm just going through my notes from yesterday. I've recorded that it may have been on her evidence itself, but I wonder whether you, via Ms. Price, could come back in the response and provide us a little bit more nuanced evidence on that particular RPS provision.
Yep, no problem.
And how it relates to the NUO3 and the change to the policy that you're recommending.
Yep, happy to.
Particularly around that avoidance space.
Mm-hmm.
Okay. The second and final question I have, Mr. Carville, is something I don't, well, you may have, if you've commented on the new evidence, I've missed it, I apologise.
That's fine.
It's in relation to NUR23.
No, I haven't commented on that.
I don't think so, but that's fine. The reporting officer has recommended the an additional matter of discretion at item 11 in the table.
Yep, I'll just find it on my screen.
Yes.
So this is rules in relation to Three Waters.
Yes, but there may well be sorry, yes. Might have to get some I have to get some assistance from Ms. Cannon. I thought there was a similar matter of discretion being added in relation to, oh no, this is underground pipeline, so isn't it?
Yes, that
yeah.
matter of discretion was added to all of the restricted
Yeah.
discretionary roles.
Yes, it was, yes, sorry, I've just picked the wrong one. So that matter of discretion appears for all of the underground pipelines. So what it's dealing with is effects on natural features, landforms, water bodies, indigenous vegetation, sites of significance that are unlikely to be scheduled or identified in the plan in some way. So they won't be captured by the interplay of the proposal with the overlay chapters, and there won't be subject to rules in the overlay chapters because they're not scheduled or identified. But there might be some unidentified significant feature or historic heritage item that an underground pipeline or an overground pipeline might impact on. And what I think Ms. Cannon is suggesting is that it's important to provide an ability for the council to consider those matters where you trigger a standard in the network utilities rules, and therefore you become a restricted discretionary activity. That's my understanding, at least, of what Ms. Cannon was saying, and she'll correct me if I'm wrong. But on that basis, is that something that you've considered and are comfortable with?
Yep. So the relevant one that I will have looked at while preparing my evidence would be, for example, R19, which has an additional matter of discretion.
Yes, sorry, I should have gone to that one.
Yep, that's right. Okay. Just through me referring to a rule that I haven't looked at.
Yes.
But yes, no, I considered that whilst preparing my evidence, and yeah, as a matter of discretion, I'm comfortable with that.
Yeah. So I think that's sort of been described as a belts and braces approach for dealing with matters that haven't been scheduled or identified or are not known. Of course, it relies on the activity triggering standards and not being permitted and falling into the restricted discretionary realm for that matter of discretion to be triggered, doesn't it?
Yes.
Yes. And it's really no alternative to that, I presume. If the standards are set at the right level for permitted activity, then I assume that the effects associated with that permitted activity are acceptable.
Yep, that would be my take on it too.
Okay, no, that's useful. Thank you for that.
Thank you, Commissioner McMahon. Thank you, Ms. Campbell. 2 questions. Supplementary really around the RPS and the infrastructure objectives. And I'm particularly interested in how the RPS deals with regionally significant infrastructure. The reason of particularly focusing on this is NPS-FM 2020, the definition of specified infrastructure, which has a clause relating to infrastructure that's defined as regionally significant infrastructure in an RPS. So it is relevant tangentially to the district plan. As we know, the RPS is mainly focused around freshwater and regional responsibilities, but there's some overlap in the district council responsibilities. So really my question is, it's probably a legal and a planning question, and Ms. Price might assist with this as well. I know in the Hawke's Bay RPS that I'm very familiar with, there is a list of regionally significant infrastructure in that RPS, but it's not called exactly that term. It's got another heading, but it's got a list of what in Hawke's Bay is defined in the RPS when you read it as being regionally significant infrastructure. There's no other way of looking at it. So it's really a interpretation matter that if the RPS identifies and lists regionally significant infrastructure, in my read of the Taranaki RPS is it does have a list and a outline, but it's not necessarily the exact title of regionally significant infrastructure in a list that refers back up to the new RPS, MPS. So really, in your view, you might not have thought about it, but is that fatal to, again, interpretation of the MPS FM if the RPS doesn't specifically list it under a heading of that title?
Just making sure I understand your question. You're concerned about whether the RPS defines regionally significant infrastructure in terms of
I'm not
MPS.
really concerned, I'm just looking for my assistance.
Yep.
The MPS FM is new.
Yep.
The RPS was developed many years ago. Taranaki RPS has a section referring to essentially regionally significant infrastructure. I don't think it uses that exact term in the RPS, but it does have a list of essentially regionally significant infrastructure we have heard from.
But by way of example, but not by definition.
By example, not by definition.
Mhm.
And we are, in this plan, we do have a request, I think, from Trustpower or one of the other energy providers for a definition of regionally significant infrastructure. And it's quite important, that term as relates to the district plan, not only in terms of MPS FM, but certainly how some of the overlay rules looked at around consenting pathways, SNAs, around SASMs, those sorts of things.
Yep.
I'm particularly interested in this topic and whether it's something, again, you and Ms. Price can just give a bit of advice on when you come back to us when you look at that RPS directive.
Sure.
Is that clear enough? Or Ms. Price, do you want to add anything on this, whether you understand the question or whether I'm not being clear enough?
I understand. Well, as I understand the question, you're wanting to know our views on the request from Trustpower for a definition of regionally significant infrastructure, given the age of the RPS and that it hasn't provided one for you.
Yes.
But I think it would be appropriate for us to come back with a written response because there's also definitions of nationally significant infrastructure that might be relevant here too.
Yes. It's really an interpretation thing that certainly in Hawke's Bay, that region has a list of regionally significant infrastructure. It's just under a different title.
Yes, and that happens in many plans, that there is a list.
Yes. So thank you. Some assistance with that would be helpful. And I think it was Trustpower seeking it. If not,
And hearing five.
Oh, hearing five, Trustpower.
it certainly was referred to in our minute 15, where we've got a group of planners looking at the SNA issues around consenting pathways for network utilities and infrastructure.
Yep. So I can confirm I was at the expert conference thing that happened yesterday in relation to that matter.
Okay.
I understand your question now. Yep.
So you're alluded to that. Sorry,
That's okay.
Yes.
It's been a long week.
Just in addition to that, sir, the minute 15. Minute 15 encouraged participants in the expert conferencing to try and land on defined terms and consistency of terminology between the objectives, policies and rules. And that was one of the observations of the panel, that there wasn't necessarily consistency of terminology that assisted with consenting pathways between objectives, policies and rules in the notified version.
Throughout the plan, not just that chapter.
Not just that chapter, yes. but in provisions within that chapter, it was very obvious. And I guess what the chair's indicating is that, that we've got some quite directive guidance in the new MPS FM referring to the term
Well, it's part of the definition of specified infrastructure.
which then draws on, as an efficient term, draws on other instruments around the country, including regional policy statements, where they might use the term regionally significant infrastructure. Now, in this case, the RPS does use the term, but it doesn't define it, but uses examples and explanations to give some. So it's not an inclusive list. Whereas if you look at the Wellington Regional Plan, it has a very, very inclusive list of what constitutes regionally significant infrastructure, and that was subject to appeals.
RPS or plan?
Plan. Yeah.
Yes.
But I think it also took its guidance from the RPS also.
Yes. All right, so I think you've got the gist. Thank you for that. And I suppose that, I certainly don't apologise for giving you some homework. Your evidence has been incredibly helpful, but again, just following through, and we've asked a number of parties to follow through and come back to us on specific questions in writing. It's incredibly helpful when we're deliberating and making decisions. So thank you in advance for that. Look, my only other question is that your paragraph 32 of the evidence, Ms. Carville, and it's where you're talking about these terms where practicable and also the term where feasible. So what's your understanding of the difference of those two words?
Yep, that's a good question. Let me just have a look at the wording of the. My recollection, and I would need to go and check, but that was the wording that was requested in the submission, and I felt that it was. I noted that there was two different words being used. I didn't feel the need to change them to match, but I think that the meaning is sufficiently similar, and particularly if practical was being defined, then it makes sense to amend that feasible to practical.
Yes, thank you. And that might be something, Jacob, that there's perhaps more of a plan-wide discussion, particularly if you're having a discussion about definition of a key qualifier, which appears throughout the plan. All right, I think that's the only questions we have. As I said, hugely appreciate the effort of the legal submissions, the evidence, basically coming along, giving us the benefit of your knowledge, and just thinking about timetables, Karen. We've got a bit to come back to us on, and this is going to be quite important to feed into the writer replies. So we did have a discussion yesterday because there's quite a bit of work Transpower working with the team on about some of their issues, and Ms. McIndoe was going to liaise with Mr. Stenner about what practical timeframes coming back to us might be on the requests we've made, and we are quite flexible to accede to requests for some longer timeframes for the right to reply if there is some dialogue going on and some more information being provided. So perhaps you could just, we're hoping certainly within a week or 10 days, but if you can just let us know, you might be able to do that now, but if not, come back to us via the hearings administrator, or would be the best, I think.
Yes, I'd like to come back via the hearings administrator because I'm aware that Ms. Carville is as busy as I am at the moment.
Yes, busy is a busy thing. It's life at the moment. Yes, so greatly appreciate all your assistance, and we will break for a cup of tea. Come back, I think, at 11:20, if that's all right. Thank you very much.
Good morning, commissioners.
Still waiting for reporting officers, so.
Oh. We've got a brief one this morning, Mr. Chairman, so
yes,
we're in and out before lunchtime.
Over before lunchtime.
The need to well, that right.
Commissioners again. We've introduced ourselves before, so there's no need to go down that line anymore. So I'll get straight on to our submission if I can. In our paragraphs 7 to 10, we present some background to our submission and the concerns we have, specifically regarding protection of our sites of significance. In paragraphs 14 to 17, we discuss the rules in general and note our concerns regarding permitted activities. And in this matter, we agree totally with the quote from Dr. Marie Brown, who noted permitted activities have the largest risk of damaging our environment simply because they are seldom monitored and the applicant seldom reads conditions that may be a requirement of a permitted activity. And that was a wonderful quote that she made, and we agree with that totally. Now, we offer a solution to site protection by way of a new effect standard wording, and that is included in paragraph 16. In paragraphs 18, we note that in rule NUR1, it may be appropriate in certain circumstances to leave redundant utilities in the ground rather than remove within a certain timeline. But we stress, though, that if at a later date these utilities need to be removed, then the previous owner must be held accountable. And we note Mr. Quinn's comments a couple of days ago on behalf of Todd, where he offered some elegant alternative wording in paragraph 49 of his evidence on page 11. And he talks about or abandoned in situ if this provides better environmental outcomes. We could agree with that, but we'd like to add the word cultural and/or cultural and environmental outcomes, but only in some circumstances. If we add that word cultural, then we as Tangata Whenua will always be involved with any decommissioning, and that's what we're after. Now, this morning, Mr. Stevenson discussed the coating of the pipelines. The most recent pipelines we have no concerns with. What we do have concerns with, older pipelines at times were wrapped in asbestos. And so any pipeline of a certain age, we would really need to consider whether it's best to leave a pipeline on the ground, which could happen with the recent pipelines. I would not like to leave an asbestos coated pipeline in the ground. It would make a bit of a mess pulling it out, but it would then be out. And so while we say that we could live with some utilities being left behind, in certain circumstances we would want work done. And I've been on projects where you see 10 or 20 people in white suits and breathing apparatus removing those pipelines. I would not want those left in the ground in our building. In paragraphs 19 and 20, we again express our concerns regarding significant sites. And it's all about the protection of our sites. And we agree with rule NUR 12 regarding overhead lines and the multi-purpose site. We agree that there should be some, that's the maximum structure of heights. And we suggest that the multi-purpose site should be put into the same, sorry, that's a different paragraph. In paragraphs 22 and 25, we summarise our submission, and there's not much that we would like out of this, Mr. Chairman. We would like an appropriate effect standard added to the chapter, simply to remind network operators that although their activities may be permitted, there are matters of much concern to us. We as a hapu should be considered an effective party on any operations within 50 metres of our significant sites. And that we as a hapu, which is not included here, be considered an effective party on any earthworks. And we've previously submitted on that in the earthworks chapter. And that's it, Mr. Chairman. Thank you for listening to us. We haven't got too much to say on this matter. Happy to take any questions there are. Thank you very much.
Thank you. I'm just sorry, I am listening. I'm just finding NUS 7 just so that I actually.
NUS 7 is a proposed new one. So
this is the new one, isn't
yes,
it? Yes.
Because if you read through the effect standards of what can and can't happen, there's nothing about natural environment. It's covered in the notes at the start. But as Dr. Marie Brown says, people don't read those notes. They read the effect standards. They read what it is they can and can't do. And a simple new NUS 7, natural environment, people will read that and know straight away what can and can't be done. And the words are no more or less than the effect standards that are listed if permitted activity cannot be met.
All right, thank you. Commissioner McMahon, do you have questions?
I don't see Mr. Holsworth. That's a very clear and concise statement of opposition. I understand your position. Thank you for that.
I do have another question. It's this practical one about asbestos. My work has taken me to this issue many times. Geothermal pipeline magging and around Taupo, the old the massive projects to remove those and lag pipelines with other facilities. My technical understanding is that because asbestos is not mobile on soil water, it's an air effects issue. The technical process is when you remove asbestos, you bury it in bags and put it in the ground. So do you see that issue around pipelines buried 3 feet to 6 feet under the ground being different? Is it a cultural sort of uncomfortableness?
There could be a cultural matter.
Yes.
On any pipeline. The asbestos most certainly is a cultural matter, but if it's left in the ground and never disturbed, like you say, maybe nothing will happen. It's a bit like roofs, asbestos roofs. If you don't touch them and you seal them, they probably last for 100 years. Those pipelines, if they become decommissioned, then people are going to start digging around them, whether it's the farmers, whether it's developers, and all I've got to do is expose that pipe and you're going to have all sorts of problems. Who's then responsible for that? The developer is going to say, it's not our pipe. The oil company is going to say, we decommissioned that 30 years ago. It's not our concern. The government and their new rules and regulations are bringing out now are going to say, it's not our concern. And that's our concern. What happens with that asbestos pipe? So I suspect there's not too many in our area. And I know the Maui pipeline most certainly is asbestos covered. I don't know which other ones are. So I'm just worried that if an asbestos coated wrapped pipeline is left in situ, there could be issues 10, 20, 30, 50 years down the line.
Yes.
And it's better to deal with it now.
And of course, Maui pipeline is covered by these rules. I know that's good clarification. It's the fact that they might be intercepted at some time and then releasing the risk pathway.
Correct.
With people perhaps unknowingly working around them and pulling them out. Yes.
That's all I have for you on that one.
Thank you very
Thank you
much.
very much.
Thank you for your attendance again.
Yep.
I think we'll be seeing, I'm not on the hearing next week, so you might be here on energy. I'm not
I'll
sure.
be here for much longer on that one, so.
Yes, Commissioner McMahon and Commissioner Coffin will be taking care of you there.
Thank you very much for your
Thank you
time.
very much. Lucky last again. Bad spot to be, isn't it? I think we're starting Debbie. We'll see her. Debbie's gonna start.
Having a laugh, this big cousin joke that would be wrong.
Yes, yes,
Yeah,
yes.
well, we just found out today that Marty told us, so
Oh,
can't roll. So. More experience, some more experience. Tēnā tātou anō, tēnā koroa e riki ana. Nā mihi nui o te wā o hini raumati, ko Sarah Mako tōku ingoa. So kia ora everybody, nice to be back again. As you know, I'm Sarah Mako, so it's just a mihi to hini raumati, so I'm not sure if everyone knows about hini raumati, so just where we're moving into the summer months now, in terms of the Maramataka, so
Would have known this, right?
it's raining today, it
Is
was
it?
not raining
Well,
yesterday.
I had no idea.
So anyway, yeah, I just, as I was thinking about writing my notes this morning, we started at Matariki, and our hearings are going to finish in Matariki, or close to Matariki at the end of May. So we're going to experience all of the feelings through the entire hearings process. But anyway, enough of the really good stuff, and on to the other stuff. So I have had the benefit of listening in on the last couple of days, and understand my evidence is to be taken as read, and have some notes that I've made throughout the last couple of days. So also just to reflect on, so Maya isn't joining us. Maya hasn't prepared any legal submissions again. Once we sort of always have her on call there for us. So if anything does arise, and if we think there's anything that she does need to respond to, she is available to provide those supplementary submissions or some initial submissions.
so she's keeping in touch with the hearing as well.
Yeah. So we're talking it through as we prepare our evidence, and if she feels that there is a legal argument to be made, or if it's a planning argument that Maria, Casey and I can make.
Right, thank you.
So I just wanted to touch on 3 key points of my evidence today. It's mostly just providing a little bit more context. So the relative importance of network utilities, and also, sorry, just taking a step back. So I haven't, at 11:10 when you went into your break, that's when I finished my notes. So I haven't sent them to Christine yet, but I will circulate them for you. So yeah, just three key points on my evidence today. So the relative importance of network utilities, i.e. not all network utilities are as significant to the community generally as others, and the implications of this with respect to the provisions, including the discussion around possible, practicable, feasible and viable. Also the citing of network utilities within the cultural landscape, including water bodies. So I was expecting there to be many more people listening today, so I prepared something very formal, but I'm hoping, because there's not as many there, and actually 4 of them are my colleagues, 3 of them are my colleagues on Zoom, so they're to support us. So I just wondered, in my evidence at paragraph 18, I've set out some instances where network utilities are located on or within
particularly sites and areas of significance to Māori that form the cultural landscape. So I wondered, do you want me to go through them on the proposed district planning maps to provide some context?
Yes. If I read those with interest. So these are examples of your own experience and how the utility operations have impacted on cultural landscape. How would that take much time to cruise through the maps and?
I don't think so.
Oh.
Ooh, go on.
Planning maps?
Thank you.
Give me a drive, Christine.
Yeah. So Jacob, another one that we'll also refer to is just the GIS, like the public maps that are available, because I want to show the utilities layer as well.
The emergency GIS ones, yeah.
So I was just reflecting on the cordial that you had with Rebecca here, and sorry, I didn't trace your colleagues. Around the engagement process. So I guess we've just reflected on those engagement processes and with network utility operators. So there's obviously a spectrum of that engagement and a spectrum of that meaningfulness of engagement as well. So always that opportunity for improvement. But in terms of these network utilities operators, and like Keith pointed out before, is there are that infrastructure which is associated with some of that contamination. So asbestos pipes, etc. So the legacy issues that those operators are dealing with, and some are trying to improve and make the environment better, the cultural landscape better. There are some that are battling to maintain the status quo still. So that's just been my experience in terms of my short time with consultation and my engagement with those operators.
So we're looking through your list starting in A.
So what we'll just start on this one first. This is number 18F. So Jacob, if you could just turn on the utilities layer, please. So if you go up the top right hand corner into the next one over, yeah, and just on the utilities. So on this one, we're going to go to Kātere Marae, which is on Cody Place. So if you just pull it to your right, and then pull it down a bit, so it's on Cody Place.
Okay.
Yeah, so just in here, so this is Cody Place.
Yes.
And this is Kātere ki te Moana Marae. So the marae of Ngāti Tawharikura. So Sarah Gibson, who's one of the kaimahi for Ngāti Tawharikura, she addressed you in hearing 5.
Yes.
So this is, and this is all my understanding and what I've been so lucky to have learned in my time with Te Koteitanga is there about the cultural landscape. So you've got Mamaone Pā here, and you've got the marae here. So this green pipe here is an infrastructure, is a stormwater pipe. So it's the council is a network utility operator. So that's just an example of the location of that pipe. So and its depth will restrict it ever being able to be, I guess, daylit there. And also restricts the opportunity for Ngāti Tawharikura to develop there as well. Second one, if you could go to the district planning maps.
Wait, can you go back to that, or is it too late? Yeah. So the waterway there seems to be a waterway transitioning through there, Sarah, just that line with the.
Could you just, zoom in. So this is, could you just zoom out?
Yes.
Zoom out again as well. So this is the Mangaone stream.
Yes.
So the Mangaone stream is a tributary of the Waiwakaio. So the Mangaone stream actually starts back over in here.
Yes.
over by Bell Block bypass,
Yes.
or the off ramp.
Yes.
And you'll see the yellow is identified as stormwater infrastructure.
Okay. So that's coming into the
It
stream.
comes all the way down here.
Yes.
Yeah, and along the back through the industrial area.
Yeah. Okay.
And much of that stream through there, it's the term revetted.
Revetted.
It's all.
Yes. Okay.
So just on that one, could you go to Orapiriri Road, please? So this is the state highway that you're coming down into what's known as, well, we would call it Kātere Hill, but others may know it as down into the valley shopping complexes. So just on the right hand side of the screen, sorry, where the grey dotted lines are, that's
yes.
But anyway, in any case, that's a site and area of significance to Māori that you can see in the middle of the state highway designation. I'm not entirely sure what that site and area of significance is, but further on the right hand side is Orapiriri Road. So that is where the state highway, when the bypass was constructed, went through Orapiriri Road. Sorry, went through Orapiriri Path.
So that's your example.
So that's that's 18A. Could you? Yeah, so these Orapiriri are the interesting shapes.
So the part of the shape there, and the bypass actually went through the edge of that.
Yeah, so there was an extensive excavation. The excavation of Orapiriri Path my understanding is it was excavated over a really long time and mapped as well.
Okay.
So that's that example there. So Mahuetahi Part is at the intersection of State Highway 3A and State Highway 3. So you might notice that if you're driving right from the north, so it's when the road was cut through, so it's got a big, just a flat wall on the side there. That's another example. So another example is the New Plymouth Airport and the process acquisition of that land, Puketapu Pa and the associated features of that as well. So I think it's a little bit difficult to see all of the sites and areas of significance to Māori that are mapped over the airport when you're quite zoomed out, but you've got Pa and Urupa at both ends.
All through that area.
Yeah.
Yes.
So that's, also the location of the port and the tank farms.
Yes.
So we've reflected on that in hearing 5 as well. So the Ngā Motu, but also there's Ōtaka Pa there, a number of Urupa all through that area as well. And it was an area of occupation up until only recently. So the Think Big projects as well, which Keith will be familiar with both of those, the Waitara Valley, and also and the Motunui plant as well. So if you can just zoom in on that even more, or identify, and if Keith may correct me, this area is has Methanex been identified as a silent site and area of significance to Māori as well. And the last one was the location of infrastructure associated with the national grid. For example, on Paritutu, Te Mahue Pa, which Trent Power spoke to yesterday, and also an unnamed power on Waitara Road. You don't need to, probably don't need to go to those, the Waitara Road one, but maybe zoom in on that one if you can. Jacob. And so Dougal in particular, Dougal Campbell yesterday mentioned the foundations of the tower, which are on Paritutu Te Mapapa, so we're working through that with them as well. Anyway, just I mean, there's many more examples, but those are just a few that I've worked on with my groups. Yeah.
So maybe this is a good time to talk about the idea of the site visit, which I think you've been raising with Julie on, which I think is we're very keen to do. And I just talked to Julie yesterday about just the logistics and how we manage that. So just getting some dates and also just, I suppose, carefully organising it so we're not interfacing with witnesses and things, but there's a range of people around that can show us the things that we need to see. We are quite looking forward to that. So just to agree with that, and that's something we can work on with Julie. But,
yeah, sure.
Thank you.
And that's something we'll speak with our hub as well. Then maybe, of course, all of that here is important. All of our here is important. But,
yes, I think we
can do in a condensed time.
Yeah, but we'll be in your hands in the time frame. Or your hands, or the hubby's hands when you liaise with the council on how best to do that.
Yeah. Yeah, so I reflected on the example that Mr. Campbell gave yesterday with Transpower. We are working with them on that Paritutu site, the New Plymouth Exit project, and also at the Huirangi substation as well, which Dougal mentioned yesterday is actually a relatively minor works on the Huirangi substation, but they've really given that appreciation to the landscape that they're working in, and their commitment to working with Pukerangi Ora in that instance, and then Ngāti Whiti and Ngamahanga, Ngāti Tairi and Te Kahui o Taranaki at Paritutu as well. Just on the siding of network utilities within the cultural landscape, just a little bit more context around that commentary. So it is therefore my opinion that clear and unambiguous provisions are required which identify the removal or remediation of network utilities at the end of life are the norm as opposed to the exception, and that those decisions are managed through a resource consent process to ensure the adverse effects of what decision is made with respect to that remediation is informed by the advice of Tangata Whenua. Really jumping all over the place, I'm sorry. So without a resource consent process for that, the removal and the remediation of that infrastructure would leave those decisions of remediation to an individual network utility operator. I consider in that instance that's where status quo will fail. That redundant infrastructure will continue to be left in the landscape, including special places for tangata whenua and those adverse effects which continue to accrue in these places and on that relationship. So just another recent example of where there's been an issue with redundant infrastructure was the Grain Corp discharge at Tallow at Port Taranaki. So Tallow made its way into the stormwater system. There was some redundant infrastructure there, and some of that tallow made its way into the wastewater system, which caused wastewater discharges to the sea.
It's not pretty, is it, when that happens?
Yeah, so about 60 tonnes of tallow. There's a discharge of about 60 tonnes of tallow.
Sarah, we've been pressing the experts for the various network utility operators about effects of infrastructure remaining in the ground. You were talking to us about the cultural effects. And as I think Mr. Holswich quite wisely said, it's probably a horse of courses, but perhaps the most important thing is some involvement, engagement about the decision and the reasons. Is perhaps as important from a process point of view, the outcomes are very important. Is that a fair summary of the position you're telling us?
Yes. Yeah. And so I've got a little bit more commentary on that as well. So,
Okay.
yeah, obviously you've heard from Keith as well around there may be instances where it's okay to leave that infrastructure in the ground, but if you don't have that consent, if you don't have that consenting pathway, then how do you have that conversation at all? So in terms of the cultural effects, I did have a quick word with Te Poihi, so in the office, and all of his cultural expertise. So he's given the analogy of, so Papatūānuku as the earth mother, and the connectedness of the environment. So Papatūānuku is the birthplace of all things, all parts of the natural environment are interconnected. The topography of the whenua can be conceptualised as Papatūānuku lying down, and she can be conceptualised as the human body. So an analogy of that type of infrastructure is introducing those foreign bodies into Papatūānuku. And in Te Poihi's example, we compared it to installing a pacemaker. That's one analogy. Installing a pacemaker, well, when that pacemaker becomes deficient or redundant, you don't just fill it with the equivalent of cement, and you don't just move it to the side and install a new pacemaker. I mean, I don't at all claim to be a doctor, or installer of pacemakers, but I'm assuming you can't just leave a pacemaker. You can't just leave a pacemaker in your body and install a new one. So, I mean, you could use that. You could use it for anything, such as a hip. If you have a hip replacement and you need it to be replaced again, again, you're not a doctor, but I would assume you have to remove it and replace it. And it's around, for us, it's whānau, that's our whakapapa to the whenua, and if it's left there, but there is an opportunity to remove it, it becomes a legacy issue for your mokopuna, for my mokopuna, for their mokopuna, and it just carries on as an issue that could be resolved in 2021 or 2022 rather than in 2050. So in terms of the cultural effects, that's how I've framed it in my mind, is if there is no consenting pathway or option, then it's, like Keith said, it may be okay to leave it there, but how do you have that conversation? And also I reflected on the conversation that Ms. Price has had this morning and Ms. Carville around, there's obviously other regimes and standards that provide for the decommissioning and remediation of pipelines as well. So I'm not aware that those particular codes and standards allow for recognising and providing for the relationship of tangata whenua with that area, or for giving effect to Te Mana o Te Wai. So, I mean, I'm generally supportive of there not being duplication in regimes, but in the instance where there is a gap, then I would assume that a resource consent process would fill that gap until those existing regimes can address all of the matters, the resource management matters that are applicable. So in our instance, those cultural values and our relationship, sorry, the relationship of Māori with Te Taiao.
Sarah, are you familiar with any modern consents for infrastructure with decommissioning conditions and actually the consent themselves rather than being driven by a plan requirement?
Not recently. But in my experience when I was working for New Plymouth District Council, so my first ever role was I monitored oil and gas resource consent conditions, and through my research of those consent applications was going back even further, looking at those well sites which hadn't been issued consent under the Resource Management Act. So in lots of instances, actually, the regional council had provided, or the previous organisations prior to the regional council, they had recommended things like that, so decommissioning plans and the like, but not so much in recent
No, I'm just
consents.
Do a lot of energy infrastructure work around the country in the geothermal space. Modern consents require decommissioning plans and quite a lot of detail thinking out of the end of life. So I'm assuming that there may be some examples, but certainly not every consented infrastructure facility would have those in the resource consents, I presume. Yeah.
And reflecting on that as well is that in some instances the infrastructure might not necessarily require consent for its installation. So an example that we've got now is the replacement of some asbestos stormwater and waste. Forgive me, I think they are wastewater and water pipes within Kātiri Road, so within Little Bear of Ngāti Tāwhiri Kura. So the council, they are asbestos pipes. So I'm assuming they probably didn't need resource consent for their installation, but now they need consent for their removal because of the NES contaminated soil under that. But the council are proposing at this stage to retain those pipes and replace the stormwater pipes over top.
Okay.
So just an example of where there may not be a consent to require that. So, and you know, in my opinion, I've considered that actually having this requirement to remove that redundant infrastructure should hopefully encourage operators to make better business decisions up front if they know that there's also that requirement for its removal at end of life.
I have a question on that, and it's not so much. I understand what Ms. Marcos is saying, and really the notes I've been taking record that you can't have a discretion and a permitted activity rule to deal with the horses and horses side by side, case by case scenario of whether it stays or whether it goes. To quote the Clash, so that would make that rule a priorities. So therefore, the most efficient entry level for that sort of rule would be a restricted discretionary activity, because if you want to say no, it can't be a controlled activity. And so is that the solution that you're suggesting? And if so, is that what your submission sought?
I'll be honest, I haven't made submissions to this particular hearing around that. I have made submissions to hearing 12 around that. Okay. We'll be speaking to that next week.
Okay. Thank you for that.
I haven't explored that any further. We do have submission scope to that, and if you thought that was something you wanted supplementary evidence on, we would be happy to do that. But
always trying to look for the solution, and in this case, through you, Mr. Chair, I have a wide concern with rule R2 and R19. And it's, might benefit for some input from Mr. Harwood, either now or in the right reply. Are you there, Mr. Harwood?
Yes, I am, sir.
Yes. And I'm directing this question to Ms. Cannon and to yourself. And that is the intent. Well, I'm still not, I don't think I understand the full intent of R2 and R19. They start up, the proposed as permitted activities permitting the undergrounding of network utilities subject to standards. So you can put in an underground pipeline provided you meet the standards in R2 and R19 and the appropriate S standards, S1, S5, I think. Is that and the reference to the structures being removed once they're no longer required within 2 years, is that a requirement of, to be a permitted activity standard, or is it intended to be retrospective for existing underground pipelines? And if so, what's the vagaries of that approach? I appreciate that's a big question, Mr. Harwood, but it's something that's just struck me today after hearing submissions on this matter over the last 4 days.
Yeah.
Do you understand my question, Mr. Harwood?
I think I do. I imagine we'll need to reflect on that question and come back to you. I'm a little bit hesitant to give you a response on the hoof, if that's acceptable.
Yes, I'm particularly interested in whether the intent of that rule, as I think all submitters have assumed it is to be respective as well as being enabling of new development.
Yes.
And if that's the case, I just wonder about the practicality and the legality of that.
Yes, it does pose a challenge if the intent is to be retrospective.
Yes, I see Ms. Cannon's appeared on the screen.
Yes.
I wonder if you had a view on that.
I just wanted to say I will need to check that as well. I'm off the top of my head, cannot recall the exact intention, whether it was meant to be retrospective or just for utilities that are installed. So I will come back on that one.
If it's the latter, Ms. Cannon, I guess the issue that arises is, do you need a permitted activity standards to put a condition on a consent to achieve that, or is that a prerequisite to having? If your application is for a structure that meets all the standards, but there's no intention to remove it after it becoming redundant, then does it trigger to an activity status other than permitted?
I think it possibly could, but it could be interpreted in different ways. So I will
Yes.
need to have a think about that and come back with you.
Yeah, thank you for that. Thanks.
And also, I've just made a note. I appreciate that and on the first day considered that the points raised in my evidence in relation to network utilities and proximity to sites and areas of significance to Māori is best dealt with during the sites and areas of significance to Māori chapter. So Te Ko Teitanga and Ngā Hapuro Te Atiawa will be preparing evidence to this chapter and merely raising this this now to begin that conversation with you and to provide more context moving into hearings 13 and 14. So in terms of touching on the point around not all network utilities are equal, I consider that a more nuanced response to this plan regarding network utilities is required. Some, like the assets of Transpower, are clearly significant and recognised as so through the NPSET, or Port Taranaki to a degree through the New Zealand Coastal Policy Statement. So this is compared with a local power distributor or the stormwater disposal network, where whilst important, I consider needs to be weighed against the restoration of the environment and the protection of historic heritage and other section 6 matters. I was listening earlier into the conversation with Ms. Carwell around the regionally significant infrastructure. Regionally significant infrastructure. So there isn't a definition in the regional policy statement, but regionally significant infrastructure is referred to in the RPS.
So you've really prompted my thinking again on this in your paragraph 15 and footnote number 3, 4. Certainly, I was going to ask you some questions about this. So this is footnote 3 is the extract from the NPSFM definitions. You can see there under B, it's interpretation of that. And that's what I'm seeking as my advice from Ms. Price and Ms. Carwell to have a think about it. But it's regionally significant infrastructure, and then the term identified as such in a regional policy statement or regional plan. So when I look at chapter 15 of the RPS, there's certainly, they do identify regionally significant and nationally important, nationally significant infrastructure, which then I think does provide high level guidance to us as decision makers, both at a RPS level, to look at obviously providing for and protecting against reverse sensitivity, those sorts of things. But also the NPSFM 2020 with your particular interests around water bodies. And I'm really interested in your evidence, both you and Marty, about this water body issue, you know, largely sitting in the regional council's gambit, but when you're making decisions about crossing water bodies from a land use pipeline route, and that discussion that Commissioner McMahon had with Mr. Stevenson and Mr. Stevenson, just about, you know, inevitably, Taranaki, wherever you go, you're going to be running across a water body within pretty short distance. So it's that decision making about routes and crossings and localities from a land use perspective, like pipeline, and the fact that you've, in my mind, pipelines are mainly up to Tuanuku, so land things, and we heard the evidence that certainly thrusting under waterways to stay, I presume, 6 feet underneath the bed, or however they organise as part of the good practice. So really, to me, in this plan, and the fact that one of the senators has asked for a definition of regionally significant infrastructure is quite important as it relates to the whole plan, and then how the whole plan deals with those in the context of other important scheduled sites and unscheduled sites. So do you agree? Yes. Yes, I thank you for setting it out in that way. I thought that was certainly pretty helpful. It does provide the direct evidence and links, I think, that we need to think about.
Sorry, I wasn't sure if anyone had drawn you to either, and I wasn't entirely involved in it and haven't had much experience in it, but the regional coastal plan, which is under appeal, it does have a definition for regional infrastructure. Noting, of course, that's dealt with in the coastal marine, well, below the mean high water experience.
Do you know whether that particular provision is under appeal?
I'm not sure.
Useful. So if it's not, then we can rely on it, presumably.
Yeah, that's in the regional plan.
Yes.
Interesting.
So also just reflecting as well in terms of that nuanced response for network utility operators, so in the instance of Transpower and some other local electricity distributors, I guess you could say, trying to benefit from the NPS ET as well, and the NISETA. So that's trying to ensure that the plan provisions recognise that as well. Infrastructure, and the discussion with Ms. Cargill and Ms. Price this morning around the practicable versus possible qualifier. So I think throwing it back to hearing one, I think that's where we had that first discussion around the qualifier wording that had benefited from the advice of Tangata Whenua through the development of the plan, so through Ngā Kaitiaki, that the Mana Whenua working group, they had explored that as well, and in my submission and my evidence to hearing one was that qualifiers may be appropriate, but should be used sparingly with clear context and with care, due to the ambiguity that they can introduce into provisions and their interpretation over time, and also the lived experience of Ngā Hapu, of Tangata Whenua, where there is this ambiguity and the results of what has resulted in the degradation of their sensitive places and the relationships that they've been able to have with those places as well. So I just noted a couple of examples. So in terms of best practicable option, and appreciate this one doesn't relate to the proposed district plan, but in relation to air emissions. So that's in the regional air plan, best practicable option. And also the NPS for freshwater management actually talks about the practicable with respect to improving the health of freshwater, giving effect to Te Mana o Te Wai. So just making sure that where there are the use of those qualifiers that are in specific contexts and are interpreted within that context.
What do you think about the court's guidance on that, and whether that could be useful?
So that is that
this is the Wakatani case where they define the, I don't know whether you were listening in when I was asking about that. It was Price and her legal submissions. We don't have a copy of those.
No, but actually, as mentioned, Maria and I did talk about it before we came over as well, and we, from memory, think that there might be another case that might be relevant as well, the Ngāti Hei case.
Okay.
And Maya may have spoken about it at hearing 5, but we're also, am happy to have Maya look into that if that would be.
Could you please, because I suppose as a practitioner, that is practicable with a loaded word. You know it's used throughout the RMA and also in the National Policy Statement, so it's sitting on the table as something that's useful, because not everything's black and white. Can't be. That's sort of we live in a nuanced world, so it is a useful term, but when you're applying that, particularly in resource consenting, understanding sort of the recipe of how you think about that, particularly endorsed by the court, could be quite useful. So if Maya could look at that,
yeah, sure.
Come back to us.
And maybe the Whakatane case, if the Ngāti Hei is it.
Yes. So there's quite a lot of things, Christine, coming your way, but you'll think this provided the supplementary legal or planning evidence, however you like to get it to us.
And in terms of that practicable versus possible, you know, just in an actual live setting, that's part of the discussion that we're having with Transpower as well, particularly in relation to Paritutu. Because in that instance, so the tower, you know, the 4 footings, to remove them will result in a very large hole.
More damage.
Yeah, so potentially will that cause more damage, so.
I was interested in your thoughts about practicable, feasible, viable. I did ask one of the other planning experts, can't remember who, about certainly when anyone that's investing in something always thinks about both feasible and viable. It's quite different. We don't have a viable descriptor that I'm aware of, so we know appropriate in a plan.
Is that in particular something you would want?
No, well,
For now?
no, I think if you're thinking about this, certainly the practicable versus feasible, and I think I'm not sure whether feasible is used when there's a control F on the plan, but I don't think it is. But you heard from Ms. Carver, she thought they were quite similar and probably have a preference for practicable. If we are going to use, which we are going to have qualifiers in the plan.
From memory, I know that with in earlier hearings, there's been that discussion around possible versus practicable,
Yes.
and how the financial and the feasible comes in there.
Certainly that quite
Not
possible.
entirely across all the.
Yeah, possible is quite different to practicable. Okay, so if Maya could help us with that, that would be
sure.
Just a cameo piece of advice.
Yeah, sure. Yeah, we will. I'll make contact with her, and I guess the same as Ms. Price, see when Maya's available to.
Yes, and we're just thinking about that and just foreshadowing for the staff. We probably are looking to have your rights reply in before Christmas, which is sort of 3 weeks away. And I said we had flexibility. The reality is we're going to be very busy February through to April, and we're trying to get as much deliberation and decision making done on the 2021 hearing matters as we can as a panel and have draft decision prepared. So while I mentioned parties that we're looking at flexibility, is sort of 3 weeks of time, so we'd like you to make things within that time if you possibly can. Thank you.
Cool. Oh, not Adam.
Thank you.
It was submission for today, so.
Yeah, any other questions?
No, nothing.
And quite a good way of actually getting through the evidence, with your summary, and if you'd like to receive a copy, just talking through the issues as we go. That's good. Right, Murray, you're up next, and last but not least.
So I don't think I have any additional points to make that Sarah hasn't kind of covered already. I guess following on from the practicable discussion, yeah, I guess practicable is used in for example, EBS FM, and so I guess reflecting on where or how it's appropriate, I think that the EPS FM, how that uses practicable is, I guess, is in context of the purpose of the EPS FM. And so if you're thinking
how practicable is used in that NPS. It's how is it practicable in order to achieve the goal of protecting Te Mana Wai. And so that's where you would get the, I guess, the criteria or the how you would judge if it is practicable or not. Whereas I think in the plan, you're looking at activities, and if you're thinking about, well, what is practicable in terms of an activity, that they're quite different.
Yes. Yes.
I guess matters that you'd consider.
So the context is important.
Yeah.
There might not be a one fits all definition.
Yes.
But that will be part of the thinking we'd like
Yes.
you to think through with Molly's help.
Yes, I thought I'd just I'd also just like to echo what Sarah was saying regarding the decommissioning work, and I'm not across this new piece of legislation that Ms. Price referenced earlier this morning. I would reflect, or I'd just note that these pieces of legislation have different purposes and or serve different purposes. And I suppose from my position as a Māori resource management practitioner, the RMA is the best place to consider the effects of network utilities and infrastructure and the effects on whānau whenua and their relationship. And similarly with the Australia and New Zealand standards, I'm not aware of how they provide for that. And so I'd just echo Sarah's point that we don't want duplication, but again, I haven't looked into that legislation to see exactly what it covers in terms of tangata whenua values and how that plays out. But I don't believe that, considering the cultural values and environmental values of decommissioning infrastructure under the district plan, I don't see that as being duplication. Yeah.
No, that's understood as your evidence, and that's yes, those regulations re standard or legislation. Quite often there's input these days in the legislation. Some of those standards, I know they have committees that develop them. This is an Australian New Zealand standard. But you can see, to me, this comes to the 32AA consideration we'll need to make about efficiency on one hand and effectiveness about the purpose of the plan in terms of how it's dealing with an issue. And I think without doubt, network utilities as an issue is massive for this district. It's an issue perhaps more prevalent than any other district in New Zealand in terms of just the combination of utilities with the oil and gas and the generation and future renewables. I sense that Taranaki is going to be a very, very important area for renewable energy going forward. So it's something we need to get right. Do you agree with that?
Yes, yes, definitely.
So just like you, the first time I heard about that act was reading the chapter Trabaku yesterday, and it was fortuitous with just good timing that this Price picked it up and has given us quite a good summary of what that involves, but it doesn't seem to include transmission lines, for example. And we're going to be supplied a copy of the standard, well, the standard I know, but we will have to think about that legislation as well.
So from my, and I haven't been involved in this, but from my understanding, part of the impetus for that that piece of legislation was around the Tui oil field. And so Taranaki iwi are working with iwi on decommissioning the Tui oil field. And yet, because Tamarind, can't remember the full name of the organisation, they went into liquidation and basically just left everything there. And that is obviously what that is of concern to Tangata Whenua, including Taranaki iwi and a number of well, all of the Taranaki, Ngā iwi o Taranaki. So Taranaki iwi have entered into a partnership with MB to work on the decommissioning, and I believe that was part of the impetus for creating this piece of legislation. Yeah.
Okay, that's again, we've learned a lot about that. So Renee, so that's good to know both those, the legal background and also the origins of how that's been needed. I had a question about your controlled activity proposal, which again, David, do you have any questions about that? You mentioned RDA might be.
Well, I guess I was responding to looking for a solution to the concern raised by Ms. Marco about how you deal with a case-by-case situation, and you can't deal with it in a kind of a matter of discretion and permitted activity. Presumably, if you want to actually decline the consent, you can't have this controlled activity. And so therefore, the next capital ranks restricted discretionary, which would require that rule to change dramatically. But as you would have heard, I'm raising a more fundamental issue about what's the intent of the rule in the first place.
Mara, your proposition is to make permitted controlled for some of these rules.
Yes.
Yes. And is that the scope of?
So the scope comes from Ngāti Mutuna's submission, where they requested that all permitted rules and in the network utilities chapter went to RDA. No, sorry, discretionary. Yeah, basically all the rules went to discretionary. And Te Kāhui submitted in support of this.
Yes.
And when I was preparing my evidence, I guess I wanted to acknowledge that there is clear, there is direction in the higher, in the higher audit planning documents, there is enabling legislation that provides for network utilities. And so I didn't, my evidence to move it to control was to provide that certainty and that to be more aligned with that high audit direction. I wasn't necessarily, I didn't necessarily think through in terms of the graduation, I guess, or in terms of RDA being a more appropriate if council wanted the ability to decline an application. So I was trying to strike a balance between.
So can we go to your appendix 1, which are your recommended amendments? So this is an activity rules NUR3, which deals with upgrading of above ground network utilities. You're suggesting that go to permitted control. And you've added some additional suggestions for control being reserved there. NUR18, which is one of the ones that Commissioner McMahon's interested in, which is a permitted activity rule, you specify goes to control with those additional matters of control. That relates to above ground network utilities, not provided for any other rule. And you've got an option for NUR19, I think. So can you just let me know the sort of the two options
For
A19?
yes, so that was if the pipelines were permitted under the by the regional freshwater plan, or if there was a consent from regional council. So if that was to be retained, then I in clause 2C of NUR 19, sorry, if that were retained as within the rule, then I sought for the rule to be a controlled rule, whereas if it was removed, then I proposed that it would stay at permitted.
But I think the most important thing you've told us is that Ati Mutunga has sought that move from permitted to discretionary. You've gone control in your evidence, but are you still sticking with that, or is that something you'd like to reflect on to us?
I would like to reflect on that, and I might talk to Maya about just to get a bit more clarity around that.
But these rules don't cover the removal of pipelines, do they? So you see that the policy direction being NUP4, where direction would come there, more involvement or control in the removal. How does that involvement, control, engagement for the removal? What's the mechanism you're seeking to achieve that outcome?
Is it okay if I just clarify something?
Yes.
Just with Rule 19, that does apply to the removal of pipelines.
Does.
Yes. Yeah.
Oh, yes.
Thank you. You're onto it, Jamie. Appreciate that. Right, look, we certainly, because this is quite a technical chapter, quite complex, we have provided the other submitters an opportunity to reflect on some of these key issues that have come up in the discussions and provide us some supplementary legal submissions or evidence. And of course, as we see, you have that right, again, negotiated with a time frame that can be achievable. So certainly interested in any other thoughts you have on this one, seeing that there is clear scope. Do you have any other follow-up questions on this?
No, I think you've covered it all.
As Commissioner Littlejohn has said, there's not much left to the witness. think you made that comment in hearing 4 when I was quizzing someone first up. You made that interesting comment. He's full of good sayings, and certainly Commissioner McMahon's succeeded in getting another music quote into this hearing. As he does in every hearing we're involved in. Try to.
What was the quote?
It's the.
Should I stay or should I go?
Oh, okay.
Disappointed if it wasn't.
Laurie, was there anything else you'd like to cover with us?
No, I think Sarah's covered a lot of,
Yes.
yeah. Happy to do it.
You obviously get me in touch with the whole plan as well, which is great. We really welcome your involvement as experts. And, appreciate the effort and the way you need to interface with the hapu and work evidence up. So I think that's the end of the evidence for hearing 11. We're going to break. Jamie and Jacob, would you like a bit of time to organise your verbal right of reply, or are you ready to go after lunch?
I should be okay to go after lunch, I think. I'll just got a couple of things to check on, but should be fine.
If we said we'd come back at 2 o'clock, would that be suitable? You've got Mr. Commissioner McMahon's got a flight at 4:30. Perhaps prefer to come back earlier, looking at his body language.
I'm also here with
1:30. Okay.
1:30 is fine with me.
Okay, great. We'll adjourn until 1:30. Thank you very much.
Thanks.
Away. Here it's been pretty well planned in terms of timing. It's always nice to finish off with time to spare. In terms of the right of reply, what's the batting order? Would you like to go first, or what's?
I'm very happy to go first unless Jamie has preference.
I'm happy with that.
Thank you.
Very good. So with that in mind, I'll start off with transport, finish on the National Grid, which will lead into Jamie's.
Thank you.
Right of reply. Cool. Well, thank you very much. So there's some matters that I can provide some clarification on today and hope to close off today. Other matters will require a bit more time to formulate a response, and these will be included in my written right of reply. I just initially like to thank the submitters that have taken the time to prepare and present evidence in relation to the hearings. I've enjoyed this process. It's been a really useful process from my point of view in drafting these provisions and getting them right. So I'm just going to respond to these matters mostly provision by provision. I'll group those together, obviously, if there's a logical grouping of construction, policy, rule, etc. I'd also just note at the front end that there was some homework that I received from Commissioner McMahon on day one relating to providing a table displaying the relevant activities listed as high-traffic generating activities and their corresponding status in the zone. So that's underway, close to finish, but it will be something that will be provided to you through the written right.
Hopefully it hasn't been too difficult.
I haven't done all of the work, so I'll say that it hasn't. Cool. Okay, so just starting on delegation, starting on Tran 01. So as a recap, Tran 01 seeks to ensure that the transport network is a well-connected, integrated and accessible system. It has 3 clauses relating to being responsive to future needs and population growth, linking with land uses and promoting public access, walking and cycling. Submitters have indicated that there is a need for provisions, or for this provision to specify timeframes as to what is anticipated for future needs, including population growth. These submissions have indicated that the plan introduces uncertainty as to what the time horizon is for future needs, including population growth. In particular, Mr. Brophy raised concerns that resource consent applicants may be unduly disadvantaged by council seeking a future development provides upgrades to the road transport network that go beyond a reasonable time horizon. There was considerable discussion on day one of the hearing outlining that as an objective, it is appropriate to indicate that the transport network meets and is responsive to current and future needs. I agree with this, and I'm of the view that this objective, as worded, gives effect to higher order direction provided by the NPSUD. I do not think that it's necessary to stipulate a timeframe in the objective. There was further discussion relating to whether some timeframe could be added to a policy or assessment criteria, presumably in the sort of the ITA and Train Rule 10. But I'm also of the view that this is not necessary. The NPSUD and district plan zoning and growth areas provided useful guidance in terms of what's anticipated in particular areas over a given period of time. I know that the NPSUD requires council to review its business and housing capacity assessment every 3 years, and this work involves assessing the growth requirements in the short, medium and long term of the district, and the district plan must be updated accordingly. I also note that strategic objective UFD 14 sets out the short, medium and long-term housing demands for the district, where growth will be expected. Do you have any questions about that objective at this point? Cool, I'll keep on tracking. So moving on to Tran 03. Tran 03 focuses on ensuring activities generate a type and level of traffic that is compatible with the local road transport network. Blue Haven and Southern Cross have questioned the appropriateness of Tran 03, which indicates that activity should, which I've just said, should generate traffic that's compatible with the road transport network. They've requested that this term is replaced with accommodated within. I maintain the view that solely referencing the ability for the road transport network to accommodate traffic is too narrow in its focus. Mr. Brophy referenced back to the example of Cowling Road, if you remember, we had a look at on day one, that narrow kind of a rural road. When discussing this, and indicated that this activity may have been able to be accommodated within the road transport network with particular upgrades and road improvements. However, I'm of the view that this ignores other effects associated with high trip generating activities and the use of heavy vehicles, such as, in that particular example, rural character and amenity. This point similarly came through in the evidence of Mr. McKenzie for Southern Cross Hospitals, where he indicated that a road's ability to accommodate traffic flow from an efficiency or performance position may not be sufficient to reach a compatible situation as the policy directs. In this regard, there is a degree of interpretation and judgment across a number of objectives, many of which may not be transportation related. He's used the examples of user amenity, residential amenity, and urban design outcomes. So I generally agree with that statement, except disagree that user amenity and residential amenity are not transportation related matters. This in itself is the primary reason I do not agree with the use of the wording accommodated within. This, in my view, it's my view that this wording is too narrow in its focus, and compatibility as an outcome being sought more appropriately addresses the relevant resource management issues. Please just stop me at any point. Yes, we will. Okay, so moving on to Tran 04, which is about ensuring the existing and future transport network is not compromised by incompatible activities, which may result in reduced sensitivity and or conflict. Again, Blue Haven and Southern Cross have indicated that this should both provide clarity as to what's considered the future transport network, and also for the objective to reference what is considered an incompatible activity by making reference to the non-complying activity status within the zone. I disagree with the suggestion that the objective should indicate that incompatible activities are those listed as non-complying activities within the zones. The activity status of land uses within the zones may have very little relevance or no relevance whatsoever to not compromising the transport network and not creating conflict. I also consider the suggested use of the word proposed before future transport network is superfluous. A reasonable consideration of what constitutes the future transport network can be made without the use of this term. Moving on to TRAN policy 4. The TRAN policy 4 relates to the indicative road network. Yeah, so TRAN policy 4 relates to the use of the indicative road network. Commissioners raised questions on day 1 of the hearing in relation to the use of indicative roads within the plan. I wonder if it would be useful at all to take a look at some. So we did a little bit of work just to identify the extent of these indicative roads throughout the district. So if we just scroll through slowly, this is Puakura, indicative road traversing a residential area. This is sort of, you can see.
Can we just slow down? Can we go back to the first one?
Yep.
So the indicative roads are the blue.
Oh, yes, apologies. Yep. So indicative road, the blue is the local road. If it comes up as green is collector, orange arterial.
That's not an existing road.
It's just indicative. Yeah.
Can you blow that up a little bit?
And of course, you can see the zoning extent of the residential zone here as well.
So this is the entire length of the blue line indicative, is it?
Correct.
And that's new residential zoning.
No, that's been in the operative plan for, I'm not too sure how long, but it's certainly zoned at the moment. It hasn't been developed yet. I believe that somebody else might be able to advise here that, no, you haven't heard of this one.
No.
I believe that maybe they're starting to look at the development here. Cool. Thanks, Christine. We've just got another link through slightly. This is close to the tank farm. Over to the left here will be the start of the tank farms, which connects through a couple of local roads. Keep going. Thanks, Christine. Patterson, so it's a bit of structure planned area through that Patterson area. The remainder of them are just indicative roads.
So that all of those blue lines are indicative roads in a growth area.
Residential.
Residential zoning, is that the Franklin growth area, Sarah? Sorry.
Sorry, my eyes are so poor, I can't. See.
Patterson is certainly a structure planned area which is coming through on the in the proposed district plan, but I think that there's that residential zoning been frankly for some time, I think. From memory. Thanks, Christine. If we can go down a bit more.
So what are the black dots? Black dot lines are
they pathway connections.
Pathway connections. This is in a similar way that the future pathways are notated as well.
This is a structure plan which has been rezoned through the proposed district plan. Area. Yes, thanks, Christine. We can keep going. A couple of short links. Near the Waiwakai River, over in the Marylands area. Yes.
This is the one that Mr. Brophy talked about.
This one was
stops, no crossing.
Correct, stops there and isn't indicated on the opposite side of the road.
Not indicated.
No. Another link through residential areas.
Yes.
Again, that one's a collector road. I understand the collector arterial roads, the ones that council visited that they will be the ultimately it's one of those, I don't want to say wish list, it's one of those ones that they have desire to construct.
So on that image, 3 blue lines?
Yes.
All indicative roads?
Correct.
And the green is
indicative roads.
Indicative collector.
Indicative collector.
Okay. What's blue?
Local.
think it's important to point out though in the plan that they're shown as dotted or dashed lines. For this purposes, we've highlighted the different colours so that you can see them.
Sure, yes, that is a good point. Thanks, Christine. This is further growth areas. There's Bell Block area and some industrial areas. If you go down a little bit, Christine, the orange indicative line through here links sort of in the back of the Bell Block industrial areas. Yes, that particular linkage is funding through the long-term plan. It will be a council project. This is structured land area Q, Bell Block, you're familiar with. There's a further, this blue link through here is the, oh no, sorry, the orange collector is the realignment of Airport Drive.
All right. Yes.
Another council project.
There's a designation for that.
I believe that would be for the, is that for the state highway, maybe the roundabout? Oh, for the road as well, okay, yes. Okay, and it's also. All right, thanks Christine. And then finally, this is for the middle area. Might be it.
Is that a gen res too?
Or within general residential, yeah.
So is that the full extent of indicative roads, or is that just a sample?
This is, we pulled out everything.
Everything.
Yeah. Also, if it's useful, just coming to mind, we've got some maps which show some proposed. Sorry, what was the operative plan operative plan draft plan and what was notified in the end, which sort of shows how they've been refined and things.
So has been any submissions?
Yeah, so that sort of brings me to my next point, I suppose, is that ultimately we this is the approach that we've got in the district plan, and we haven't had any submissions on the substance of that approach. There's been some around the you know, please move this to the other side of my property, or I don't want it going through my property, but not on the actual use of the indicative road per se.
So people that have asked for those changes, they would have normally turned up at this hearing or the zone-based hearing?
I know that it's scheduled for the planning map hearing.
Planning map hearing. All right. Yeah. Okay. So as a tool, it's in the plan, hasn't been challenged as a concept. So yeah, thanks for that update. I'm just a bit scarred by listening. You're not happy with them, but there's no scope to change them. That's the approach. So yeah.
There's the lines on planning maps. You're saying there's no scope challenging those lines.
Yes,
generally. Presumably we got to this because there's some submissions relating to the provisions relating to those lines. So
correct. In this instance, I suppose it's that submission from Blue Haven, which is that link across the Waikato River.
yes, and is Blue Haven challenging the provision generically, or are they challenging it just in relation to that?
Just in relation to that, secure that secure as such that route.
Okay, because we were involved in the designation hearings, we were aware that at least one of those indicative roads, the orange arterial one at Airport Drive, is subject to a notice of requirement. Are any of the other ones subject to them? You're aware of?
Not to the best of my knowledge, but I will have to come back to you on that one. And just to round out that indicative road conversation, so obviously here we heard from Blue Haven in relation to identifying a second crossing of the Waikato River and linking up with Smart Road. I just note that I maintain my position that was put forward in the section 42A. I don't think it's appropriate to do that at this stage, and I've also just noted here that there's been no targeted consultation with any landowners that might be affected by that. In my view, I don't think they've really had a reasonable opportunity to be involved in the district plan process, particularly when there's certainly the couple of options that Mr. Brophy identified. There's a lot of uncertainty about where things will, that they will be involved in this, so yeah, I've just got some issues here, I suppose.
There's one of those indicative roads, I think it was an arterial, you said it had advanced stage where it had long-term planning, funding under the long-term plan.
Yes.
I can't remember which one it was.
The road that runs under the Outlook Industrial, kind of links Headwood Drive and
From Colson Road through to.
Thank you.
Okay. And the indicative road in itself won't provide, the indicative roading notation itself won't provide for that road though, will it?
No, all the indicative road provides for is basically protection of that corridor.
Through a setback.
Through a setback for buildings, that's right.
And the protection of a policy, and the basis of the policy.
That's right. Yes.
Thank you.
Thank you. Sure. Okay, I'll move on to Tran P11, which relates to additions and upgrades to the road transport network. So we heard from Blue Haven again on this, without questioning the need for Tran P11 to indicate what is being considered, that what's being considered are localised additions, and that it relates only to urban environments. I don't agree with that position again. I think the primary intent of this policy is to ensure that any additions or upgrades to the road transport network can meet certain design standards, and to ensure the safety and efficiency of the network. This policy is not necessarily directing where additions will be required. I also disagree that it should be limited to urban environments. I think it's pretty clearly a wider network matter, not just an urban issue.
Steno, after we get past Tran P5, the numbering changes, are you referring to the operative numbering or the new numbering?
Sorry, anytime I'm referring to numbering, it'll be the new numbering. I hope.
So
moving on to Tran P15, this is a policy which we heard about on day one again, which is about encouraging car parks to be designed to provide clearly marked, connected, convenient, safe pathways and shelter where possible. So there was a bit of discussion from Mr. Brophy on day one around just clarifying that the intent of this is to consider public and staff car parking. I'm pretty comfortable with that. I think it would provide some clarity to that policy. That ultimately, that's what we're interested in. That's the intent of the policy, is to capture those things. So if that provides that clarity, then I think that's a sensible idea. Moving on to Tran P16. So policy Tran P16 was discussed at some length by submitters. So this is the policy which seeks to ensure that the type and level of traffic used in the road transportation is the network is appropriate by minimising the ability of heavy vehicles to access local roads, requiring high trip generators to locate on arterial collector roads and or avoiding, remedying, mitigating adverse effects. So the submitters questioned the language used in the first two clauses of the policy, indicating that they were too directive and need softening. It was suggested that this was done by either including qualifiers or by softening the introductory words, minimise and avoid. So I agree with submitters that there will be instances in which the use of local roads will be appropriate for high traffic generating activities and heavy vehicles. I also agree that state highways are an appropriate part of the network for which high traffic generating activities should be able to gain access. This was a question raised by Mr. Quigley, and I think we might have clarified that that was the intention on day one. As outlined in the evidence of Mr. Brophy, there's substantial areas of local roads within, for example, industrial or business zoned land. Oftentimes, these roads will be the most appropriate locations for the use of heavy vehicles and high trip generating activities. The position I put forward in my section 42A report is that the provision is to be read conjunctively, and that the and or clause contained within the policy provides some indication that there are instances in which this may be appropriate. So, for example, if clause 2 can't be met, then clause 3 becomes engaged, and it will require the decision maker to look at the avoidance, remedying or mitigating of effects I do note here, though, that some reservations about that approach were raised by Wapa Kotahi, by Mrs. Hepplethwaite, Ms. Hepplethwaite.
The and/or issue.
The and/or issue, yeah. So I've, in some ways, I've relied, I suppose, on the and/or to provide, because I think the submitters are correct that minimise and require a very strong terms, and then I've relied somewhat on the and/or to provide some flexibility.
Why wouldn't the word "or" achieve that flexibility on its own?
Yeah, I think it probably would.
I mean, if you look at that, the way that's constructed as a menu by either 1, 2, or 3. I mean, I'm not sure what the and adds to that. And in fact, it could actually add a requirement that you have actually got to consider all 3.
Yes, take that on board. I think that the or though that follows provides that either kind of a approach. I think when I was initially considering this is a really good point. When I was initially, sorry, it wasn't a very good point. When I was initially considering this, I think I was looking at it that those first 2 clauses do what they do, the and or, so you avoid, remedy, mitigate. I mean, that could still be an appropriate outcome, or you avoid, remedy, mitigate. But I take your point that it's the end is probably not helping anything.
From an interpretation point of view, it just sends me into a spin every time I see that. That's just the way my poor brain works. Have a think about it.
Yeah, good to know. Cool. So just picking back up where I left off, Mr. Brody indicated that the policy should be deleted in its entirety on the basis that the remaining provisions provide for the outcome sought. And I think he referenced specifically TRANP 17 and 18. So these remaining provisions relate specifically to the use of ITAs and the effects of construction traffic, where I think that TRANP 16 is much broader than that. So don't agree with the deletion. I'm also concerned with the use of the qualifiers and softening the language to too greater extent. Ultimately, I don't want the policy to be watered down so that it's ineffective. But on this point, I appreciate a bit more time to come back in my written reply, consider that conjunctive, the way that policy works, and turn my mind to that a bit more. Okay. Moving on to TRANP 17, and one of the key conversations that was had on day 1 was around the use of road maintenance agreements and whether the removal of that specific piece of the clause, clause 3, and the need for road maintenance agreements, whether the balance of the provision, that is the effect of the ongoing maintenance of the roads, sort of still directed, I suppose, decision makers to think about road maintenance agreements as part of that. So this came through obviously in the addendum on day 1, and then Commissioner McMahon correctly noted that there was still a requirement in clause 5 of TRAN R10. I agree that this should be removed. So I understand the point that was made by submitters here, but my preliminary view is that the clause is now worded doesn't impose any maintenance obligations as such. High trip generating activities should be required to assess effects generally on the road transport network. This might include capacity and effects on road users and potential effects on the ability to undertake ongoing maintenance of the road. It's possible that given this has sort of resulted in a bit of, I guess there's some disagreement there, I'd be quite happy to think about how that might be reworked into another of the clauses within that policy. Just as an example here, clause number 1 could be something along the lines of the road's capacity and the likely effect of the proposed activity on the road, its ongoing maintenance and its users. It's another one that I'd be keen to spend a bit more time just considering and getting my position clear on. Thank you. Moving on to reverse sensitivity requirements. Sorry, the stars that jump around slightly from the actual order of the plan. So Kāinga Ora have requested the deletion of Train P7. Activities are appropriately located and separated from state highway and rail. They have also requested the deletion of rules relating to the setback from the rail corridor. I understand, I acknowledge the points made by Kāinga Ora that this policy has a very much a noise framing to it, I suppose. But I still maintain the position that the policy is appropriate in this chapter. This policy relates to achieving the transport objective TRAN 04. While the noise policies also apply and would achieve a similar outcome, this policy is directing the use of setbacks, which is not covered anywhere in the noise policy itself. And this transport policy directs the setback rules in the zones where there's, in the zone itself, there's also not a directive policy. So I suppose I see it as that linking through from the policy through to the rule in the zones. Anything at this stage?
I think that's a useful clarification. It wasn't clear from your 42A that was the case, and that there was a sort of perhaps a gap in the zone rule in that precise manner. So,
yeah,
thank you for that.
I will note there as well that I think I'll go away and have a bit of a look at I think the end of that policy does reference acoustic insulation and things like that, which I think might need some tidying up a little bit. I'll have some conversations perhaps with the reporting officers on the noise report and get that straight.
Yes, but certainly there's two methods to achieve or to reduce reverse sensitivity. One is setback, the other is attenuation through noise attenuation through funding or through at the receiver.
Yes.
So I mean, if you're saying that this policy gives effect to 04 by relating solely to setbacks, and that there's no equivalent policy in the noise chapter or rules in the noise chapter related to setbacks per se, then that's a point of distinction. Yes. But if there's some overlap, maybe there's some fine tuning.
Yes.
Necessary.
Yeah, I agree. Yeah. Good, thank you. Just moving on to the rules and standards. So I'll start at Train R8, which is sorry. Yes, I will start Train R8. Sorry. So this relates to, this is a rule in relation to the indicative road transport network. So this is where a structure is located as it stands within an allotment containing an indicative road or within 20 metres of the road or 5 metres of a pathway connection. Is automatically restricted discretionary activity. I think we heard from Ms. Johnson from Johnson Resource Management on day 2 in relation to this, and she raised some really valid questions, I think, around how that is what we're trying to achieve a 20-metre setback, and if so, is it appropriate to trigger a consent when it's a dwelling or a building anywhere inside the allotment? So I agree with Ms. Johnson on this point, that I think that it shouldn't relate to within an allotment in general. It should just be those setbacks that are trying to be protected. Moving on to,
sorry, is that a potential alteration to clause 1 then?
Yes, that's right. I think my view essentially is that I don't think clause 1 is really achieving anything useful. Thank you. Moving on to Train R9, which is the high trip generating activity rule and associated train table 1.
Train 10.
Yes. Train R10. Thank you.
Still sharp.
So
I know too much for my own good.
I'll just start off with some general comments in relation to this rule and in the table. So several submitted serviceable changes to the high trip generating activity in order to clarify its use. Given the misunderstanding and some mechanical issues that have been identified in this rule and in table, I can see that some refinements warranted. I'd like to give this a bit of further consideration and testing, and will include some suggested alternatives in my written reply. I note in the evidence of Waka Kotahi have sought. I note that in the evidence of Waka Kotahi have sought both hourly heavy vehicle movement thresholds be added to the catch-all of activities. Given the original content of their submission on this table related specifically to setting a threshold of 250 vehicle movements for education activities, I'm not clear as to whether these changes can be made. It's something that I'll have to go away and have a bit more of a look at the scope of in their submission to.
I think the road witness, I think of his name offhand. Rossiter, Mr. Rossiter, yes, suggested that it's possibly not something that had been covered specifically in the submission.
Yeah, and I think we started having conversations with Heppelthwaite, was going to look into it, and then maybe the conversation moved on. But right, anyway, that's what it is. But yeah, something I'll have a look at. Irrespective, after receiving feedback from Ms. Taylor, I'm of the view that maintaining a single daily threshold is most appropriate. This provides a clear and easy standard to interpret. Moving on to construction traffic, submitters have raised concerns in relation to the directive within policies to prepare a construction traffic management plan for traffic generated by construction activities. They've indicated that there needs to be a single threshold set for this. And they've also correctly identified that lots of construction details aren't known until after the consenting process, oftentimes. As was clarified on day one of the hearing, the intent of the listing of construction activities within Tran Table 1 was not for it to be additional to existing activities on site, but rather for it to sit essentially as its own listed activity, I guess is the way that I'd think about it. So throughout that some of that session on day one, Commissioner McMahon requested that I have a careful consideration of the policy and rule framework in relation to construction traffic. To ensure it's clear what is required, it was also requested that consideration was given to including some type of threshold within Tran P19 around when a construction traffic management plan might be required. Commissioner McMahon also questioned whether consideration be given to using a controlled activity status in relation to construction activities. And sort of along in a similar vein, Commissioner Dash indicated that it might be appropriate to specify some information requirements, particularly in relation to the process for considering certifying construction traffic management plans. So I take on board these points raised by the panel. I haven't formed a final position and would appreciate taking some time to better consider this, and particularly, I guess, in terms of the point about the links between the policy, the rules, and things, just to work through that a bit. I'd note that the intention of the policy and rule framework in relation to construction traffic was for the consideration of larger scale construction activities. As notified, the policy potentially provides a lever that could be applied for smaller scale activities. In short, my initial view is that as drafted, there are some disconnects between the policies, rules, and assessment criteria and direction to provide an ITA for that matter within these construction traffic related matters. I think there's a potential for a more refined drafting that provides some clarity on these points.
Yes, my immediate observation is that the scale factor seems to be missing from, and it's P18, I think, the new number. Seems to be lacking from that lead sentence, and that what is a very long policy actually.
Yes, it is.
The way an ordinary reading of that is it's construction. It's regardless of the scale that would trigger that policy.
Yes. No, I appreciate that. Just moving on to some other specific listings and sort of queries, both with the rule and probably with the listings themselves, I guess, more generally. Kaima Ora presented evidence to suggest that the threshold for residential developments to be considered a high trip generating activity should be increased from 20 residential developments, 20 residential dwellings or 20 allotments up to 50. In presenting his evidence, Mr. Campbell for Kaingaora very usefully directed us to some of the provisions within the subdivision chapter, which potentially resolve, I guess, some of the matters that you might expect to be covered by an ITA, for example. However, I would appreciate more time on this point as well. It would be useful for me to have some, for Ms. Taylor to have some time as well, and for me to understand, I guess, some of those wider issues that we're trying to address through that direction, and to make sure that there aren't any disconnects in what we're trying to achieve by removing that or by increasing that to that extent. So we'll come back on that point as well.
I think a good analogy there, Stina, is the one that you used earlier about the setbacks from transportation corridors.
Mm-hmm.
You know, if it was solely noise as the in terms of attenuation that was being sought to be achieved through the two policies, then it's arguable that one policy, one set of rules, the noise chapter can do that.
Yes.
But if there's another technique that can add to that and it relates to setbacks and that relates to a chapter other than the noise, then that's fine. So I guess if you apply that analogy here, it's again whether what's going to do the heavy lifting, the subdivision or the transportation, and I won't say any more than that, but that's really this argument, I think, that consideration.
Yeah. Commissioner McMahon also raised a really valid point about whether that rule as drafted would provide an incentive. I'm not sure if that's the right word, but it would provide for people to do piecemeal development, I suppose.
That perverse outcome.
That perverse outcome, yeah. So that's something that I'll consider and have a look at submissions and have to think about as well. Thank you for raising that one. The oil companies presented evidence indicating that service stations should be removed from the table of high trip generating activities. They've also provided an alternative approach for existing and additions to service stations. Again, Ms. Taylor and I appreciate the time to give this some thought. I think there's sort of a couple, in my mind, there's a couple of pieces to this question. One is that, I guess, if we're looking at for refueling pumps, it's sort of a technical matter. I guess the other part is, does the rule as drafted appropriately provide for those existing and clearly provide for those existing and potentially additions to existing activities across the board? So I think that's probably something that needs a bit of refinement based on the submissions and evidence that were received. Quite nailed it in the version that I've guessed.
I think we had a discussion with Mr. Brown, the transportation for the Mr. Rossiter for the oil companies.
Oil companies didn't hear
Mr. Brown.
Blue Haven?
Oh, Mr. Brown.
No, he wasn't Blue Haven. Sorry, remember.
Might have been Mr. Rossiter.
You might have been Mr. Rossiter about the difference between modal shift and meeting minimum standards, and major cities and function of a ITA and how it works best planned in that respect. I think he accepted that service stations were largely relying on passing traffic and as their own right didn't generate a lot of new traffic, used a 5 or 10% ratio. And that just raised in my mind, what would an ITA do if it wasn't going to deal with modal shift on something that's not going to benefit from modal shift to service station? And I think the answer was partly provided. Sorry, I keep forgetting her name.
Ms. Taylor.
Ms. Taylor, sorry, Ms. Taylor. And that it could be about how tracking paths are formulated. I accept that in relation to a new service station, but for an existing service station, those tracking paths presumably have been lawfully established and appropriate. The question would be whether the additional 4 or Bowsers or whatever change that at any period. So I'm not trying to give an answer. I'm just indicating some of the tensions that exist in that rule. I guess there's also a relationship back to, and it's not a service station example, but a matter that Mr. Quinn raised in respect to the Tide Energy matter about providing, rather than starting off as entry level as restricted discretionary, for existing activities, he wanted to see a replication of the rule for existing to provide for section 10, yes, existing use right situations now. I'm not sure who's going to comment on that. Ms. Cannon, or you?
That would be me.
Yes.
I think we talked about this briefly. I can see some logic in what he's suggested there in terms of that approach of having a permit standard, taking aside their actual.
I don't think he's seeking to change the outcome. I think he's just trying to provide some mechanics to achieve the outcome.
That's right. Yeah, that's right. So again, I'm putting aside the point about. I think there's some wording about lawfully established activities there for a second.
So that lawfully established component sort of applies to some of these activities in the table 1, and where there's might be extensions to them. So just a question of whether you'd want to capture those in table 1 or not. So maybe you could just give some thought to that if you want to reply.
Yeah, very good. So the oil company, so Ms. Barth, the oil company's also had a suggestion around the ITA being commensurate with the activity that it's assessing. I can see some merit in something along those lines, so I'd just give that a bit more thought, think about some implications and whether that wording is the most appropriate, and report back.
Yeah, I think she was trying to provide some guidance to plan users. Obviously, once consent is lodged, I mean, there's scopes under section 92 to require further information and additional information. So, but you know, if that assists clarity and guidance, I'm all for it.
Cool, very good. Moving on to education activities. So this listing was questioned by the panel, given the majority of these activities at designated sites, which is a valid question. I just quickly note that not all education activities are designated. I am only aware of one exception, to be fair, within the district. But yeah, that's just my knowledge. I guess my thoughts are that while this listing might not often be engaged, I think it's appropriate. I think it's still appropriate to have it in here, and will provide some relevant guidance, I guess, of considering a new designation, for example, or the like. I gave a bit of thought. We had some discussion around the use of such a tool through an outline plan process. Had a bit of discussion with the consents planners to get some idea about whether that would be a likely scenario. Their thoughts that generally no, it wouldn't be something that they would engage. But in saying that, oftentimes within the district, we're looking at an additional classroom here or there, as opposed to any sort of substantial change, I suppose. So I think across the board would appreciate a bit more time really to go away and think about that rule and that table and the thresholds that are in there.
It got a fair thrashing, didn't it?
We've got a bit of immediate
ideas.
Yes.
And quite usefully, we had the second Whangarei or Whanganui consent order. Whangarei consent order there. First one touched on the setbacks from networks. The second one touched on this very matter. And it's now part of the evidence, I guess. So some consideration of that.
Yeah, I agree. That would be useful. Yeah, very good. Sorry, I'm jumping back slightly here, but at Tran R1, Mr. Baroffi for Blue Haven indicated that the matter's discretion within this rule were too broad, excuse me, and should be refined. I think upon reflection, they are quite broad. I think they still relate to obviously traffic and transport matters, but they could probably be refined down a bit. I'll be refined to provide a little bit more guidance to plan users. So that's something that I'll speak to Ms. Taylor about and work through. At Tran R11, yeah, this relates to vehicle access on state highways, so there were some clear deficiencies in the wording that were outlined by Ms. Johnson and Waka Kotahi. Basically, there's
less or more.
Yeah, less or more, and I think there's a disconnect about what the status of limited access roads is. So that's just I think that in my mind's an easy fix.
Yeah, not all state highways are limited access road, I think was the point made.
Yeah, that's right. Tran S20. this relates to, a bit worried now that I've got my numbering.
It's 20.
That's right of ways.
Yes, it is.
So in relation to the right of way standards, I agree with the evidence of Ms Johnson that there are some inconsistencies with the provisions that need to be addressed. The table suggested by Ms Johnson also provides quite a useful way of displaying that information. It's something that I'm keen to just take away, have a look at how it fits in with the plan structure more generally, see that it works, but definitely something that I'll consider. So myself, along with Ms Taylor, will also go through and just ensure that the correct references to specific parts of 4404, for example, are referenced where they need to be, and make sure that that is all clear. And I'll just speak briefly to removal of references to Council's land development and infrastructure standard. I've had some good conversation about this already, and I sort of maintain the view put forward on the first day that I think there are some refinements that can be made within the chapter. I acknowledge that, and I think that there can be some good balance put around those standards, I suppose, insofar as they relate to the transport chapter. So that is everything I've got for the transportation chapter. Yes, as it stands. Happy to take any questions. Otherwise, I'll hear from you in a couple of weeks.
I think most of these are obviously important, but there's nothing major that you've got to ponder from a infrastructure point of view or anything else. It seems to me that you're working on refinement. Just reflecting on Ms Johnson, who's a practitioner, based submissions are pretty handy. Someone putting it all across it, not with a particular interest other than I suppose. Certainly quite helpful throughout. So yes, and certainly feel free to liaise with others just to if you need any more information. We're looking for a good outcome. So nothing more on that. So you'll move on to Transpower.
Yes, nothing further, Ms Taylor.
Thank you very much for your help.
Taylor.
Okay, so moving on to matters relating to the National Grid and Transpower and Claim Awards submissions on this point. I'll say from the outset that there's quite a bit to go away and work on, I think, in relation to this particular topic, but I'll do what I can here and maybe set out a pathway, I suppose, move forward. So there's several areas where I generally agree, accept and agree with some of the points that Transpower has made. They've highlighted where some corrections are required to more accurately reflect the wording of the NPS ET as well as the setter. I consider that these changes are appropriate and should be made in order to give effect to these documents. I agree with the point made by Transpower that where they've suggested amendments to NUP4 to be clear about which network utilities are required to be underground in new areas of particular development. So essentially, the intent of this policy was to apply to new electricity distribution, telecommunications and 3 water services in new areas of urban development when there's an opportunity to underground network utilities that will service the new development. So it's not intended to relate to, I suppose, these national grid matters or the transmission towers generally.
Yes, I think Ms Radid provided some wording that captured those specific utilities.
Yeah, she did. Yes, quite some useful wording. Yeah. Transpower have indicated that policy NUP6 should be reworded to give effect to the NPS ET insofar as the policy should clearly state that the activity should be managed to avoid reverse sensitivity effects. The wording of the proposed district plan is to limit this as far as practical. Kaimō have also suggested amendments to policy NUP6 clause 7 whereby they have requested that the wording indicate that activities minimise reduced sensitivity effects on the national grid. I agree with the evidence of Transpower on this particular point. This is one that came up yesterday, and looking at, I believe it's policy 10 of the NPSET, is quite a clear directive, I guess, in that policy about what the wording here, what the most appropriate wording to use here will be. Transpower suggested changes in relation to NU R32 and NU R33 to retain existing vehicular access to the national grid support structures. NU R34 to clarify the standard that vertical holes are unlikely to result in a reduction in clearance distances between the ground and conductors, including reference to the New Zealand Electrical Code of Practice. I agree with all of these suggestions. I think they clarify the intent and basically what we're seeking to achieve anyway. So just some outstanding matters in relation to the national grid. Transpower of the view that the PDP does not give effect to the NPSET. They consider the plan does not recognise the particular characteristics of the national grid that mean that adverse effects cannot always be minimised. A further key issue is the requirement of the plan to provide a policy for the development of new pieces of the national grid. Thus suggested this is achieved through new policy NUPXX, which we discussed at some length yesterday. In relation to Transpower suggested additional wording to NU02, which we also discussed yesterday, where they have sought the qualifier as far as practical be added to recognise that network utilities are limited by operation and technical requirements in their ability to avoid, remedy, and mitigate adverse effects. My preliminary concern is that the inclusion of the as far as practical text in the preamble provides unlimited qualification to the requirement to avoid, remedy, or mitigate. I think this is one of those ones that, again, I'd be quite keen to take away and give a bit more time to consider how that works, how we can give effect to the NPSET without necessarily giving that kind of unlimited qualification if it's not necessarily what's wanted, I suppose.
Mr. Steno, is your concern there with the qualifier per se or the choice of word to signal the qualifier? We heard from Ms. Price this morning about an alternative word, practical, to the extent practical or whatever.
Yes.
And which is, maybe it's just a deviation of the beliefs upon Transpower. I'm not too sure, but I guess my question is it the qualifier per se, or is it the wording of the qualifier that's troubling you?
Possibly a bit of both in there. I guess the words are obviously very important, and depending on the qualifier used, it potentially would have quite a different outcome. I think it's the qualifier in general as well, the use of a qualifier in that particular limit that provision as well is a little bit concerning.
These new national policy statements using new terms and seek to avoid rather than really mitigate this. Plan making is not as easy as it used to be.
Do you accept the distinction that the NPS is providing a very direct higher order direction that's absent for most other utilities?
Yes.
That the national grid, I think Ms. Marco accepted that this morning, that the national grid is special, recognised it through that the NPS, which one of the early NPSs, I think, wasn't it? 2008, yes.
No, I acknowledge that it is. Yes, it does stand on its own, I suppose.
Yes. Yeah. Ms. Brad also drew on the INF policy and the RPS, but I got the impression she was relying more on the NPS itself for the special treatment approach.
Yes, I think so. I think that is the case because from memory, that INF policy in the RPS is relating to network utilities in general. Yeah.
It does use the word, the RPS does use terminology such as far as practical, I think.
Yeah, it does at that policy level. Yes.
Okay. Well, clearly a lot to think about there.
Yes, I agree. I think that is one that will take a bit more thought and just having a think about that specific wording within the RPS and just trying to understand how we can affect those higher order documents, I suppose.
Yes. And just, I wrapped on about these warrant diagrams a lot, but thinking about the objective as a statement of outcome, a goal to be achieved, and what that goal is for the national grid,
yes,
and then the policies to give effect to that and provisions that sit under that. That's where the efficiency issue and most appropriate comes in. But once you've got those objectives established, and we've heard the chair's comments about the strategic objectives in that respect, and the use of the word avoidance. So that's all part of the mix too.
Absolutely. Just moving on to that development of the national grid part of the conversation. So the panel requested that some work was undertaken by Transpower and reporting officers. This includes some work for Transpower to undertake what I understood to be a sort of gap analysis in some ways. I'm not sure if that's quite the right term, but to look at what the gaps are, I suppose, in the proposed district plan and how their proposed new policy fills some of those gaps. Or, am I right in that was the intention? The panel also requested that some workshopping was undertaken in relation to the proposed policy and maybe more broadly just that conversation, is that the right way to do it, or could it be broken up between chapters? But I think there's some further discussion to be had with Transpower there. So I'm generally supportive of that approach. As indicated yesterday, I think I'll have some conversations with the team and form up some opinions about the overall plan structure and how this might work, and then we'll liaise through with Transpower and set this up. I have heard from Ms. McIndoe this morning just around some timeframes of when they might be able to produce some of their information. Which is pushing out slightly, and possibly
we gave them the open door yesterday, didn't we?
So kind of could look at then finalising this by Friday, 17th of December. I think this is sort of the overall body of it. Yeah. So I'd be quite keen to have a little bit more of a think about timeframes if that's appropriate and acceptable to the panel, and come back and just make sure that I'm not setting myself up to fail here.
We've that's the last thing we want. Yes, too, there we've had requests through Sarah, Ms. Edwards, about extensions for report backs, and she had accepted them all. And as we said, Commissioner McMahon's writing this chapter, so he's quite keen to get us all some amount of information together. So it's a balance between just not being able to do the job properly pre-Christmas and then going into the new year. So just come back to us with a request, I think, after you work it all through.
Will do. Okay, thank you. So I'll put that to the side for now, and we'll come back to you and we'll look at those at that time. So just moving on, I guess, to what's the final matter really in relation to the national grid is this more nuanced and evidence-based approach that Kāinga Ora has sought in relation to the subdivision corridor, the spatial extent of the subdivision corridor. I generally agree that the proposed district plan should only impose restrictions on urban land use where these are necessary to manage potential risks and adverse effects to the national grid. So the opportunities for the Sorry, so that the requirements of NPSCT are met, but that opportunities for intensification under the NPSUD aren't necessarily lost. I note that the panel requested some items of information from Transpower in relation to how the corridor measurements are derived. This would be really useful information for myself to consider, I guess, before progressing to make it a recommendation. I think that provides some really useful guidance on.
In fact, that was missing evidence for us. We had the expert, but
that was the 2012 chief engineers
memo, and he did mention that had been reviewed by other engineers, and as a method to underpin quite a important part of the plan. At least we'll know what the basis is, because it is under challenge from the Kaingaroa perspective.
Yes.
Over the needs of another MPS, so I think that will be helpful to you and to us.
Yes. I think what's particularly under challenge is not so much the technical evidence, but the planning and legal implications of that and how it's actually shown. I think Mr. Matheson conceded that he wasn't bringing any technical evidence to challenge the dimensions. So if we're to rely on it, we want to make sure. I think Mr. Campbell's present, Mr. Dougal Campbell, he'll be listening in. That the way in which those spans and swings and corridor have been established has been subject to a thorough peer review sign-off. Then the question for us is, well, what's the best way to put that in the plan? And that's where Mr. Matheson and Mr. Campbell for Kaingaroa's evidence comes into play.
Yes. So yeah, I guess in essence, this would be another matter that would be useful to have the benefit of that particular piece of information and some more time to consider. I just had some initial comments, I suppose, if that would be helpful. I know that the extent of the national grid into the New Plymouth urban area is not particularly large. It's on the outer edge. It does traverse some areas of future urban zone. I've got a note here, 16.5 hectares. I might just need to double check that I've got that. This is the GIS run thing, so it should be accurate, but that's the sort of order of magnitude, I suppose.
Maybe if you can just append the planning maps with blocks of those areas where it traverses, because it wasn't just future urban zones. I think it was a couple of peninsulas of the residential zone too.
Sure. And I'd also just note that the PDP doesn't preclude sensitive activities necessarily from occurring within the National Grid subdivision corridor, the outer area of the National Grid, which would be subject to restricted discretionary activity. I believe. So I think that Transpower might have made the point that they don't see it as sterilising the land as such, that there's a pathway there. So that's just the final point that I'd make on that.
Yes, restricted discretionary activity for the corridor, non-compliant for the yard, I think was the.
That's right, yes. Yeah. And that really brings me to the end of my right of reply in relation to National Grid matters as well. If you take any questions.
No, I think you're on the right track, and it's been a interesting few days. We would have thought transport and utilities are interesting, but they've all got their own thing, haven't they?
They do. It has been interesting.
Yeah, thank you for your assistance and participation. It's been really, really good.
Thank you. Yes.
Thank you. Ms. Cannon, I think we're moving on to you.
All righty. So just feel free to interrupt me and ask questions or request further information as I work through my right of reply.
Thank you.
So my name, as you know, is Jamie Marie Cannon. I'm the author of the Section 42A report for Network Utilities, with the exception of Transpower submissions and related further submissions, which are the recommendations of Mr. Jacob Steiner. This is my verbal right of reply based on the written and oral evidence presented by submitters on the Network Utilities chapter. I intend to expand on these matters in my recommendations in my written right of reply. So I've grouped my verbal right of reply into key themes and issues. A number of submitters highlighted where there were various wording changes that could be made to help with plan interpretation, clarify the intent of provisions, or to provide technical accuracy, which I support. In particular, PowerCo and the telecommunications companies made comments relating to the cross-referencing to other chapters to make it clear that the rules for the zones chapters do not apply to network utilities.
Let me just bring your microphone up a little. Yeah.
Okay, can you hear me better now?
Yes, thank you.
Good. So the first key theme is increased recognition of tangata whenua values and sensitive natural and physical resources. So iwi and Hapu have highlighted the failures of the operative district plan in protecting historic heritage and providing for the relationship of tangata whenua with their lands, water, sites, wāhi tapu and other taonga from network utilities. They have requested changes to Objective 1 and various policies to better reflect Section 6 matters. I acknowledge and recognise that tangata whenua have a relationship and values that extend across all environments, and accept that there is a need to consider the adverse effects of network utilities on cultural and tangata whenua values, which needs to be balanced against the technical and functional requirements of network utilities. In general, I maintain my view that it is more efficient to rely on the relevant policies in the overlay chapters, which set the direction and expectations for the protection and management of effects for each scheduled feature. As requested by the hearing panel, in making my recommendation in the right of reply on this matter, I will consider the right of reply for the subdivision chapter and the outcome of expert conferencing on the eco chapter, which was directed by minute 15, with the aim of achieving consistency throughout the proposed plan in relation to how the district-wide chapters address scheduled and non-scheduled features and provisions. I will also seek to ensure that any recommended provisions, including matters of discretion, are directive, certain and clear in their intent. The next issue is impact of network utilities on water bodies.
Sorry, Ms. Cannon, sorry.
Yeah.
I'm just making notes as you go, sorry.
Yep.
Thank you. The consideration of the right of reply on subdivision and the conferencing as a result of minute 15.
Of the eco chapter, yeah, minute 15.
That's good. And you listed a couple of other things about certainty, etc.
Yes, I think just because it was unclear in terms of interpretation what the matter of discretion I had recommended was trying to achieve. So at the moment it refers to significant features.
Yes.
And it wasn't immediately clear to yourself whether that was referring to scheduled features or non-scheduled features or both. So
yes.
I will consider that and make sure that the intent of the matter of discretion is clear.
Yes, can you just confirm for my benefit what the intent was?
So the intent was that it was to apply to non-scheduled features. Okay. And my assumption was that the overlay chapters were achieving their role in terms of protecting the Section 6 matters.
Yes, okay, thank you for that. The only other thing I'd add to that is consistency of terminology.
Yeah.
Yes.
Thank you.
It was an issue for the eco chapters, you might recall, from the right of reply.
Yeah. Thank you. I will make sure that's addressed.
From the minute. Yes.
Yeah. And then in terms of impact of network utilities on water bodies, we've heard from iwi and Hapu who have raised concerns about the impact of network utilities on water bodies. In particular, they would like to see network utility provisions that do not result in a loss of values to water bodies by ensuring alignment with the water bodies provisions of the proposed plan, and requesting removal of the recommended exemption for gas or petroleum pipelines permitted by the Taranaki Regional Freshwater Plan or a resource consent issued by TRC. I acknowledge the concerns raised, and I will consider how the provisions can be amended to address these matters with regard to the recommended water bodies provisions of the proposed district plan.
Yes, presumably you'll be led by the overlay process in terms of your earlier comment about relying on listed water bodies and where they're not listed, relying on getting that matter of discretion into the utility standard rules.
Yes, yeah, I will be considering that, and also considering how the water bodies rules manage earthworks adjacent to water bodies. I understand there's been some changes made through, recommended changes through the hearing process, so I just need to look at that in a bit more detail and make sure there's not any overlap in terms of what I'm recommending.
Yes. Well, whilst we're on the matter of water bodies, and I should have asked you at the time, and I didn't ask any of the other submitters, what was the intention of that standard that talked about where there's been a consent issued or where it's a permitted activity in the freshwater plan? What was the intent of that? What was that trying to achieve?
It was intended to reduce duplication with the Taranaki Regional Council processes. So that's essentially recognising that pipelines within water bodies are primarily a regional council function, and if the district council doesn't need to go there, or if the district council consent process doesn't add value, then there's no need for it. So that was the intention.
They were oars, weren't they?
What was that, sorry?
Those list of matters that form part of were disjunctive, weren't they? They weren't conjunctive. They were, didn't they have the word or?
Yes, I think it does have the word or. I'll just need to check. Yeah, that's right.
So if there was a consent issued or it was a permitted activity in the freshwater plan, that would be sufficient in its own right to avoid that rule being triggered. Is that?
Yes, that's correct.
And you're lucky to have the writer reply in for the water bodies chapter to look at how that's been done. So it's good timing, I think.
Yes, definitely. Thank you. The next issue is the impact of network utilities on sites and areas of significance to Māori and historic heritage. So we've heard from iwi and Hapu that many existing network utilities have been constructed on sites and areas of significance to Māori, both scheduled and unscheduled. And as a result, these network utilities continue to adversely affect the relationship that tangata whenua can have with those places. The scheduled sites and areas of significance to Māori in the proposed district plan represents an incomplete record of the sites and areas which do hold significance to Māori. And the current approaches of relying on the Heritage New Zealand Pouhere Taonga Act, which are the Archaeological Authority processes and Accidental Discovery Protocol to manage effects on unknown or unidentified SASMs, are not effective and have resulted in destruction of sites and areas of significance and historic heritage. So as a result, Te Kahui o Taranaki has sought that the activity status for various rules for network utilities is amended from permitted to controlled activity status. And we heard today that it could potentially be restricted discretionary activity status, indicated in discussions which they were going to come back to us all on. And Ngāti Rahiri has also sought to be involved in all earthworks within their rohi because their sites of significance are yet to be rediscovered, and they sought a new effects standard to that effect. In terms of my response, the notified SASM chapter includes a controlled activity rule for network utilities, which includes maintenance, repair and upgrading activities and associated earthworks, which also includes requirements to notify tangata whenua of the works in advance of earthworks commencing. I do not think it would be appropriate to apply a blanket district-wide controlled or restricted discretionary activity status to all upgrading activities, above ground network utilities and liquid petroleum or gas transmission pipelines throughout the district due to potential effects on unknown or identified sites and areas of significance. This approach may result in a large number of resource consent applications for activities which could have very limited environmental effects, and this would not be an efficient or an effective way to achieve the network utility objectives. I consider that Ngāti Rahiri's suggested new effect standard is too subjective with no measurable thresholds and lacks certainty. So I wouldn't recommend that it is inserted into the plan. I have discussed these matters though with the reporting officer for the sites and areas of significance to Māori chapter. We consider that these issues are best considered and addressed within the sites and areas of significance to Māori topic. So the 42A report and the hearing, which is coming up, which will consider the most appropriate way to ensure that sites and areas of significance to Māori are recognised, protected and maintained from all types of activities. Moving on to managing adverse effects of incompatible activities on pipelines. So this is specifically related to policy 7. We heard from Todd Energy in legal submissions, who has sought that its gas transmission pipeline network is mapped in the proposed district plan as the gas transmission pipeline corridor. As mentioned earlier in the hearing, we do not think this decision request is contained in the original submissions by Todd Energy and may be out of scope. We will seek legal advice and confirm our position on this matter in the written right of reply. But as requested by Commissioner Daish, we will look into what options are available to us to ensure that this, or to what options are available to enable this request to be assessed as part of the district plan review. Is there any comments on that?
No, it's yeah, good to have a bit of time to work through that. I think, Jamie, it's not an easy one. So just get the best amount of information you can and advice, and let us know where you end up on that.
Cool, thank you. So policy 7 and the associated rules for activities within the gas transmission pipeline corridor manage land disturbance and earthworks within all zones, subdivision of land within all zones except the residential zone, and sensitive activities within the rural, general, industrial, open space and recreation and special purpose zones. First Gas seeks greater protection of the gas transmission network from gas transmission sensitive activities through a new gas transmission sensitive activities definition, which covers a wide range of activities where large numbers of people are likely to
Jamie, we've lost your audio. Can you hear us? No.
I'll just do.
He's obviously not using Energizer batteries for longer lives. Battery.
Can we test with someone else? Because it's got the green light there now.
Can we've lost Jamie on the audio. Anyone else listening in can speak to us, and we'll see.
Oh yes, I can hear you now. Can you hear me?
Right. Yes,
okay.
I can hear you now.
Sorry. Okay. Where did I get to? Where was the last time that you? Last
You're
thing
very
that you heard?
intently speaking to the screen, and probably for about a couple of minutes.
Oh, okay.
So,
Sorry about that.
You've certainly gone past the Todd issue. You're onto the First Gas transmission network.
Yeah. Okay. First Gas.
For more protections.
Oh, sorry.
Yes. Okay.
Yeah.
So in terms of First Gas requests, they've requested larger setbacks of 30 metres for sensitive activities from their compressor station sites, which are part of the gas transmission network. They are also seeking that rules for sensitive activities and gas transmission activities are applied to all zones, including the residential zones. And I'm not sure if you got the first part of that, which was the new definition of gas transmission sensitive activities, which includes a wide range of activities where large numbers of people are likely to gather and or where people cannot readily evacuate in the event of an emergency, and a new restricted discretionary rule for gas transmission sensitive activities within 60 metres of the gas transmission network, and reference to gas transmission sensitive activities within Policy 7. As requested by the hearing panel, I will review First Gas's original submission to determine whether the submission provides scope and sufficient certainty on the requested changes to setbacks from the above ground structures and changes to zones which the rules apply to, which would enable potentially affected landowners to participate in the process in accordance with the principles of natural justice. I do have reservations about the gas transmission sensitive activity provisions sought. While I acknowledge a pipeline failure scenario would be catastrophic, I am concerned that the requested provisions would not be proportionate to the risk. My main reason for this is that 97% of the land that the gas transmission pipelines traverse is zoned rural production, where the likelihood of gas transmission sensitive activities occurring within 60 metres is low. Also, most gas transmission sensitive activities are not compatible with the rural production zone and would require resource consent under the zone rules. Given the context, my initial view is that the low risk does not justify the need for a blanket 60-metre setback rule for all new gas transmission sensitive activities across all zones. The protection of network utilities from incompatible activities needs to be appropriately balanced with the efficient use of land. Subject to the outcome of the scope matter, I will give consideration to the 30-metre setback from compressor station sites, reference to gas transmission network, and applying the gas transmission pipeline corridor rules to all zones. In my recommendations, I will consider the mechanics of the rules. My initial view is that it would improve plan efficacy if the 30-metre setback from the compressor station sites was mapped as part of the gas transmission pipeline corridor. As requested by the panel, I will also consider how the PDP can better reflect the process and the purpose of risk assessments as part of the resource consent process for activities establishing within the gas transmission pipeline corridor. As discussed by Mr. Stenner in his right of reply, the introduction of a section in the proposed district plan dedicated to information requirements will require discussions with several chapter authors. Moving on to the requests from PowerCo and the oil companies. So PowerCo and the oil companies have sought that Policy 7 is amended to apply to, PowerCo first has requested that Policy 7 is amended to apply to gas distribution pipelines so that these are protected from incompatible activities. The key issues raised during oral evidence were land disturbance affecting pipeline integrity. The oil companies has sought that Policy 7 is amended to apply to its liquid petroleum pipelines so that these pipelines are protected from incompatible activities. The key issue raised at the hearing was potential intensification of residential activities in close proximity to the liquid petroleum pipelines along Centennial Drive in New Plymouth. The oil companies, PowerCo and Greymouth have all sought amendments to Policy 8 to ensure that sensitive activities avoid reverse sensitivity effects on network utilities in general. None of these submitters are seeking any corresponding rules or setbacks for third-party activities to achieve the avoidance directive. Kāinga Ora has sought that Policy 8 is deleted or clarified to limit consideration to the specific effects that it is seeking to manage. I acknowledge the points raised. The key matter I'm grappling with is that Policy 7 is a plan-making policy, which is implemented by the rules for activities within the gas transmission pipeline corridor. I have concerns that amending this policy to include other pipelines that do not have the associated setback rules will confuse the policy intent. Policy 8 is a consenting policy, which enables consideration of the location and design of sensitive activities relative to existing network utilities to minimize reverse sensitivity effects. This policy is intended to be implemented through the resource consent process. Although minute 9 from the independent hearing panel provided interim guidance proposing a new objective which seeks to ensure reverse sensitivity effects are avoided for infrastructure. In my view, it is not always possible to ensure that all new sensitive activities are designed to avoid reverse sensitivity effects on all network utilities. Seeking avoidance of reverse sensitivity conflicts district-wide for sensitive activities in all network utilities could unduly restrict land use activities from establishing and would require further changes to the plan provisions to achieve an avoidance outcome, such as setbacks or buffer areas from all network utilities, including where there may not be a significant resource management issue. I think it is most appropriate to amend Policy 8 to address the resource management issues of concern to submitters. While I do not support an avoidance directive within Policy 8, I think the policy could be strengthened to clarify the specific effects and issues that it is seeking to manage, to give effect to the higher order documents, and to achieve objective NU03, in particular, ensuring that the safety of network utilities is not compromised by other activities. I will look at how Policy 8 can be amended, and if necessary, will indicate whether my amendments would benefit from expert conferencing with the submitters planners. I will advise Ms. Edwards and Ms. Stryker should a process be required, but I'm also happy to liaise with the submitters outside of an expert conferencing process, if that would be a benefit to the panel. As requested by the panel, I will also make comment on any inconsistency with the avoidance directive and strategic objective IE1 and recommend any associated amendments to strategic objective IE1 to achieve alignment throughout the plan.
Thank you. Jamie, we're pretty comfortable with you liaising directly outside of expert conferencing.
Okay.
Just be clear in your right of reply what you've done. So it's all open and so certainly, I've said more than once, you know, getting together with a range of peers, working through tricky issues quite often gets to a good resolution, and we're certainly encouraging of staff to work with the other experts. You know, they've got evidence on the record, submission scope, certainly no problems on our behalf with you having some further discussions. But as I say, just record how you do that and who you've talked to. I think that's good.
Yeah, okay, thank you. Moving on to Policy 4 and insertion of where practicable throughout the provisions. So PowerCo has made submissions opposing the requirements to underground new service network utilities and expectations regarding mitigation of adverse visual effects through landscaping or the use of recessive colours in Policy 4. Both PowerCo and Greymouth also oppose the absolute requirement to adopt sensitive design reference within this policy and seek insertion of where practicable to provisions to recognise the practical realities of network utilities. We've heard today from Iwi and Hapu that qualifiers like practicable can be appropriate, but they should be used sparingly with care due to the ambiguity that they can create. I acknowledge the points being made and recognise that there are other parts of the proposed district plan that use the term where practicable or similar. I will consider how Policy 4 and related matters of discretion can be amended to address these matters and clarify the intent of the policy. I will also consider the most appropriate level for these types of qualifiers within the plan. So whether it's objective policy, matter of discretion, or several of those. And also consider the appropriateness of a definition of where practicable in accordance with the criteria from the relevant case law to assist plan users with application of the policies or matters of discretion. Noting this would have plan-wide implications, so it will need to be discussed with several authors of different topics in the council team. Any other comments from the panel on that matter?
No, I think you know we have sort of really appreciated the way that these matters have evolved through the hearing. Some good ideas and thoughts coming through. So yeah, just as long as you feel you've got enough direction from us about where you're focusing, if you're happy with that, we'll let you carry on.
Okay. In terms of removal of redundant network utilities, rules 1, 2 and 19 in the recommended provisions require that network utility operators remove redundant structures within 2 years of being replaced or becoming redundant. Several submitters have highlighted that these requirements could lead to perverse and unintended outcomes, which may generate more disturbance and adverse effects than leaving redundant infrastructure in situ. They have highlighted that decommissioning or removal of pipes is subject to landowner agreements or easement terms and is appropriately regulated by other legislation and industry standards. I note that Greymouth's relief sought and planning evidence is certain and generally supported by other network utility operators. Iwi and Hapu have acknowledged that in some situations it may be more culturally and environmentally appropriate to leave the structures in place, but seek that they are involved in discussions with network utility operators to determine the cultural effects of removal or otherwise, and the consent process through the proposed plan would enable those conversations to happen. The standard requiring removal of redundant structures was originally inserted in response to concerns raised by the Ngā Kaitiaki group during the preparation of the proposed district plan, and the concerns were primarily about the ongoing effects of redundant infrastructure on cultural values. The intention was that the standard would apply to existing infrastructure that becomes redundant. So for example, when an existing structure is replaced by a new structure as part of an upgrading activity, then the standard would require that the redundant structure is removed as part of that activity or within 2 years. I acknowledge and understand the points that have been made by the submitters, and I do need to give more thought to this matter. I will require the following outstanding information from which will assist in determining the most appropriate option. So we are waiting for some information from submitters on the costs and environmental effects on leaving redundant infrastructure in situ versus the costs and environmental effects of removal. Also, we will need to obtain some legal advice on the legality of requiring the removal of existing infrastructure through a permitted activity standard, which would come into effect after the infrastructure was put in place, as was raised by Commissioner McMahon today. I will also need to ensure that my recommendation does not lead to inconsistencies with the energy chapter. I do note the energy chapter contains a policy 10, which relates to remediation of sites containing redundant or decommissioned above ground structures. And I understand that this policy is subject to submissions of a similar nature to the network utility chapter, which is being heard next week, I believe. Moving on to the permitted activity status for pipelines up to 13,600 kilopascals. Greymouth has sought permitted activity status for new or upgraded pipelines up to 13,600 kilopascals in the rural production and major facilities zone because it considers that the environmental effects are similar to pipelines of 2,000 kilopascals, which are permitted under Rule 19. Todd Energy supports Greymouth's request and has highlighted that it owns and operates 140 kilometres of pipelines which are above 2,000 kilopascal pressure limit, and this would mean that Todd Energy would regularly need to seek restricted discretionary consent for safety improvements to its existing pipelines. I acknowledge the points being made by Greymouth and Todd Energy and appreciate the evidence that has been provided to help explain the difference between the scale of the pipelines, the environmental effects, and the potentially perverse implications of this standard. I will consider these matters in detail and provide my recommendation in the written right of reply. And the last matter is the maximum height in the future urban zone. So PowerCo is seeking an increase to the maximum height for structures in the future urban zone from 15 metres to 25 metres. The future use for land in the future urban zone is yet to be determined and does have potential to be zoned residential in future when it is ready to be developed for urban purposes. Until the land is rezoned for future urban purposes, land within the future urban zone can only be used for agricultural, pastoral, and horticultural activities. It is unlikely that new services in these areas would precede future rezoning for urban purposes. So I maintain my position that a 25-metre high pole in the future residential zone would be visually dominant and obtrusive and would not achieve the objectives of the PDP. So that is my verbal right of reply. Is there any other matters you would like me to address or any questions?
Just on the last matter, Ms. Cannon, because I raised it yesterday or the day before, does the future urban zone, when permitting those pastoral farming type activities, set out bulk and location standards for those?
I would need to check that, but I believe it would either default to the rural zone bulk and location standards, or it includes its own bulk and location standards.
So there could be a rural activity that could involve a structure, a silo or whatever, up to 25 metres as a right in that zone.
I believe that the maximum height for buildings would be less than 25 metres. I would need to check that, and I can possibly address that in my written right of reply.
I think it's important that you do.
Yeah.
Yes.
So you want to see a clear distinction of the what is enabled as a permitted activity in the future urban zone and this 25-metre height. Okay. I can look at that. Thank you.
And yeah, that was everything you've captured, all the other points on my list.
Yes, so as a process, you've both done extremely well on this verbal right of reply process. Thank you very much for that. I think it does really focus, and brings together the list of issues right, as we're actually working through, provide the list of matters to really focus on. So, we find it useful. It's a process where we can chip in with any other thoughts as we go through that may have been missed, but I think you've both been pretty comprehensive. Excellent work to both of you in terms of the whole hearing, and as you would have seen, we're really encouraging of wider sort of discussion as we go through with the other practitioners, and thank you for your part in that. So I think at 3:10, we'll close hearing 11. Not sure whether there's someone that might volunteer to close us with a closing karakia.
Could I just quickly ask a question, one more question? Sorry. I just wanted to request a time extension if possible for my written right of reply, just because we're waiting for some information from submitters that might not come through till the end of next week, or the timeframes are to be confirmed. So just wondering if it would be possible for my right of reply to come through or be due on the 23rd of December, which would be an extension by 5 working days.
Yes, that's fine, and that's granted. Thank you.
Okay, thank you.
Right, so we've got anyone would like to finish our hearing would be appreciated. Maria.
Kia ora koutou. Thanks again. And see you next week, although not you, Commissioner Dash, but see you next week, Commissioner McMahon and Christine and council team. Thank you again. Unuhia I te uru a tapanui, kia wātea, kia mama, te nākau, te tinana, te wairoa, I te ara takatu koe ara e rongo wakiri ake kei runga, kia wātea, aira, kua wātea, hau, pai marere.
Thank you very much, Maria, and go well, everyone, for the rest of the week and the weekend. Thank you.
Thank you.
Bye.
Bye.